Good afternoon and welcome, everyone. I am Michael Cahill. It is currently my privilege to serve as dean here at Brooklyn Law School, and it is also my absolute pleasure to welcome you to this conference celebrating our treasured and beloved colleague, Roberta Karmel. Later this afternoon, starting at 5:30, we will have a reception that will give an opportunity for some more personal remembrances and observations and memories of interactions with Roberta. But for the balance of this afternoon and tomorrow, we are going to have a large and impressive group of scholars here to reflect on Roberta's own large and impressive body of scholarly work, which includes well over 60 law review articles and book chapters, multiple books, a popular monthly column in the New York Law Journal. Her scholarship, of course, is not only voluminous, but also impactful, having been cited by courts or by her peers nearly 1,500 times. I'd like to take a moment in introducing this conference to note some of Roberta's contributions beyond her scholarly contributions that we'll be talking about for the next day and a half, and particularly in three categories. First, of course, she had a long history of contributions to the profession and to the society at large before she even arrived at Brooklyn Law School in 1985. Having shattered any number of glass ceilings in her professional career, becoming the first woman to serve as a partner at Rogers & Wells, the first woman to serve as a commissioner on the SEC, the first woman to serve on the board of the New York Stock Exchange and many other corporate boards. So she served as a role model and mentor to generations of women to follow and made just remarkable contributions. And then, of course, arriving here in the mid-'80s, made indelible and lasting contributions to this institution, serving as a mentor to junior faculty, helping found our Dennis Block Center for the Study of International Business Law, also helping found our Journal on Corporate and Commercial Law, and serving any number of times as chair of our appointments committee, highlighted perhaps by the 2002-03 hiring season when we brought on no fewer than 6 tenure track faculty members who Roberta shepherded through. As someone who can say with confidence that I was the 6th of those 6 hires, I am delighted that Roberta went the extra mile to make sure that we would attract as many people as we possibly could to this fine institution. She's been just as significant to the life and culture and success of this institution over the last 3.5 decades as any other single person. And of course, in addition to serving the profession at large, serving this institution, she has spent decades serving our students and our graduates. She has taught literally thousands of people who have gone on to varied and successful careers at law firms, in government, in-house at various corporations. And she has served not only as a teacher, but really as a mentor and guide to them through law school and throughout their careers. And I'm pleased that some of those former students will be joining us over the course of the next day and a half. So I am thrilled to have this opportunity to celebrate all of the many accomplishments and contributions of Roberta Karmel in a wide array of domains. Let me take a moment before introducing Ted Janger to kick things off to thank some of the people who have made this day possible. I particularly want to thank not only Ted, but Miriam Baer and Jim Fanto on our faculty who organized this event together on behalf of our Center for the Study of Business Law and Regulation. I want to thank the student editors of the aforementioned Journal of Corporate, Financial, and Commercial Law who are going to turn today's papers into a volume of the journal. And of course, I want to thank the people who are enabling this event to happen, our spectacular event staff, led by Liz Alper and Chris Gibbons. Many, many thanks to all of them for working so tirelessly and seamlessly to make this and many other events run as smoothly as they have. I am now happy to turn the virtual podium over to my colleague, the David M. Barrs Professor of Law here at Brooklyn Law School, as well as our Associate Dean for Research and Scholarship, Ted Janger, the advisor to our Brooklyn Journal of Corporate and Financial and Commercial Law, and a very solid running buddy. Ted.
Thank you, Michael, and thank you for that introduction. You just saved me 3 minutes of introducing myself. I should say, in all of those capacities, I have Roberta to thank for not only founding most of those things, but then handing them off to me so I could do the work. In addition to those roles, I've also known Roberta on and off since childhood, where she first made her appearance as my brother's friend's Philip's mother, who was moving the family to Washington, D.C. for a few years. So my presence on this program is maybe a bit overdetermined. Indeed, I want to take a couple of minutes to consider the meaning of the term Festschrift, because we've called this a symposium, but this has been conceived in the tradition of the German Festschrift, a celebration and a book that celebrates the scholarship of a valued colleague, usually happening on their 70th birthday. It is important to recognize that this is has nothing to do with, nor do we want it to be confused with, retirement. The idea for this celebration grew, and actually several others that we're going to be having over the course of the next few years, grew out of a conversation a few years ago with Andrew Gold, who you'll meet later. We had recently hired him to teach corporations, securities, regulation, and torts, and he asked me the question that seemed sort of odd at the time, which is there a Brooklyn school? I said, well, we are a law school, but what do you mean? And what he said was, no, is there something distinctive about the brand of scholarly thought that we produce at Brooklyn Law School? And this, it seemed to me, was an important question for a law school like Brooklyn. We're independent. We don't have a football team or a drama school or a sociology department. And we are unique, I think, amongst independent law schools for having a very strong set of scholarly values, a uniformly productive family. But was there something special? Was there a special sauce? And Andrew's question ran deeper to ask, does Brooklyn have an intellectual and scholarly brand? And I pondered. I said, on the business law, private law side, I think it does. And I think it also does on the public law side, longer conversation. But to a person, our faculty writes theoretically sophisticated, ambitious work, deeply grounded in institutions and practice, thoughtful, and always aimed at and of interest to lawmakers and practitioners. To put it more succinctly, our heads may to varying degrees be in the clouds, but our feet are always firmly planted on the ground. And while success has many parents, some of these values can be traced to our history as a professional school, while others can be traced to David Traeger's, the dean several deans ago, decision to turn us into a national law school, in large part with a set of hires that included Roberta. When I arrived a little more than 20 years ago, it seemed to me that there were several people who embodied scholarship at Brooklyn. They were the late Margaret Berger, with her work on Weinstein and Berger on evidence, Aaron Tversky, who had just finished restating the law of product liability, Neil Cohen, who was redrafting my second most favorite statute, the Uniform Commercial Code, and Roberta, who was fiercely focused on the regulatory parts of securities regulation. 20 years on, that's still who we are, and it's due in no small measure to Roberta. As Michael mentioned, Roberta has done multiple stints as chair of the hiring committee, and we're virtually all here in some measure because she hired us. Not me, that was Susan Herman, but pretty much everybody else. And this conference is sponsored by the Center for the Study of Business Law and Regulation, which Roberta founded, the Brooklyn Journal of Corporate Financial and Commercial Law, which she championed on behalf of the students. The Center for International Business Law is or should be a co-sponsor, And all of these are committed to both to what I would call the law part of business regulation. As a business law faculty, we care deeply about markets, but we want them to work well, not just faster. We want our students to know that as lawyers, they should seek to make markets honest as well as efficient. And at Roberta's insistence, we always make sure that our work is relevant. So to come back to today's program, each of today's and tomorrow's panels will highlight Roberta's contributions across the fields of securities regulation and corporate governance. The first panel focuses on the SEC and its enforcement policies. The second panel recognizes that securities markets are global and considers international harmonization. The third panel, our first panel tomorrow, considers corporate governance. The fourth considers the structure of securities markets. And the fifth looks at the role of financial services intermediaries. And it doesn't just look, it also looks and considers Roberta's role in shaping regulation in all of these areas. But together they consider the interaction between private securities markets, private financial services providers, enforcement institutions, and the law. In this regard, and finally to close off, I want to make a few thank yous. This would not have been possible, and Michael already thanked them, without Jim and Miriam, who really took the laboring oar in putting together the program. And they have pointed out and said to me that they needed, that it would not be complete if I didn't also thank Arthur Labey of Rutgers Law School, who worked with them to help line up the panel. I want to thank all of you for taking the time to write your papers and to think about Roberta's career as we take stock in that. And just to close, I want to say that one of the things that is remarkable about Roberta is that she has never shied away from the complexity of markets or the complexity of legal institutions. She's looked both with a clear eye and a strong sense of what the law required, both of market actors and enforcers. And that is a key attribute of the Brooklyn approach to private law, that we deserve well-functioning markets, but that we end up getting the markets that we deserve. So most importantly and finally, I want to thank Roberta for being Roberta. You deserve today's tribute and today's retrospective, and we have all learned from you, and today gives us a chance to let you know just how much. With that, I hand off to Miriam, right on time.
Indeed you are. All right, so good afternoon, everyone. It is my great privilege to open up our first panel. And the name of the panel is actually Regulation by Prosecution. And indeed, not sure it's showing up too well, but this is Roberta's first book that came out in 1982. It reflected her views after having served as, among other things, the first female commissioner on the SEC in the late 1970s. And it reflects her views and her criticisms, among other things, of the SEC's approach, particularly its enforcement approach and its way of making policy through enforcement in the time period, both preceding and leading up to when she herself was a commissioner. As some of you already may know, if you read the bios, Roberta herself got her career started in the SEC's enforcement division in the New York regional office. So she was no stranger to the SEC. Today in our panel, we have four amazing panelists who'll be speaking about enforcement and also thinking about Roberta's ideas as they talk about enforcement. We have Professor Jim Park from UCLA Law School, who began his academic career as my colleague here at Brooklyn Law School. And he's actually going to speak about a chapter of his forthcoming book on securities fraud. We're then going to actually talk about enforcement, indeed, disgorgement. Donna Nagy, a professor and who served in a number of associate dean positions at Indiana, will be joining us then and talking about her views of disgorgement and a conversation she has been having for some time now with other scholars, including Roberta. And then we are lucky to have with us not one, but two former directors of the Division of Enforcement. We have Linda Chapman Thompson, and we have Richard Walker, who also, in addition to having served as director of the Division of Enforcement, also had been counsel to the SEC. So we have really a quite general counsel to the SEC. So we have quite a lineup. I'm going to start us off by asking Jim to take the reins, and just a reminder to everyone. So after everyone's had a chance to talk, we will at some point open up the conversation to the audience. To the attendees out there, if you have a question, what we ask you to do is please put that question in the Q&A. And later, when we open it up to the group and we open up the conversation, I will be basically monitoring the Q&A for questions and read some of those questions aloud and get the group to answer. So just again, reminding you, put those questions in the Q&A. Thank you so much. Jim, take it away.
Thanks so much, Miriam. Thanks for inviting me to participate in this event. It's really good to see you and Roberta and everyone else, even though it's remotely. Here's my copy of Regulation by Prosecution. I keep it on the shelf in my office. It's signed by Roberta. She gave it to me the very first time I met her, which is when she interviewed me at Brooklyn Law School. And I keep it next to this book, which is a book about my former boss, Elliot Spitzer. It's also signed. And so it sort of reminds me of the different influences in my life and career. For all of her strong views on these issues, Roberta was open-minded enough to hire someone and mentor somebody who had a different perspective than her. And I really benefited from being her colleague. So let me share my screen. I do have a few PowerPoint slides. I'm going to speak mainly today about securities enforcement during the 1970s, when Roberta was an SEC commissioner. I'm going to talk about my chapter, but more specifically, I'm going to discuss Roberta's criticism of SEC reports of investigation. The decade began in 1970 with the bankruptcy filing of the nation's largest railroad, Penn Central, which had only been formed a couple of years before, in 1968, through the merger of the New York Central and the Pennsylvania railroads. The Penn Central scandal is known by many corporate law scholars as marking a very significant event that shook confidence in the competence and integrity of corporate managers. I view it, though, not only as a problem of corporate governance and corporate scandal, but also as a securities fraud. And in a book that I'm working on public company securities fraud, I argue that Penn Central is a seminal securities fraud case. The SEC published an extensive report weighing in at about 392 pages on Penn Central under its power pursuant to Section 21A of the Securities Exchange Act. And in this report, I believe, although if somebody thinks otherwise, please let me know, I believe this is sort of the first place where the SEC sets forth an extensive theory of public company securities fraud. The theory the SEC asserted was a very broad one. I might describe it as a shareholder wealth maximization of securities fraud. Part of the reason Penn Central misrepresented its performance until the very end was the pressure to continue delivering results to the marketplace, to continue showing that it was increasing its earnings and not suffering the significant losses that it actually was. And this marks a very important development. Prior to the late 60s and 1970s, we were in what has been described as the managerialist period of large public corporations. And that was a time when public company managers did not face so much pressure to maximize profits. And so to see this theory come out in 1970 to me is a significant marker in the evolution of the public corporation and the evolution of the problem of securities fraud in public companies. viewed from the perspective of today, when reading the report, I would describe it as being somewhat freewheeling. Not a whole lot of citation of law or statutes, which I think is partly Roberta's concern about these SEC reports of investigation. And part of the reason, I guess, is it's never going to be scrutinized by a judge. And in fact, if you read the report, much of what the SEC describes is probably not conduct that would be viewed as securities fraud today. A lot of the conduct described in the report is Penn Central selling off assets kind of at the end of the quarter, end of the year in order to meet various earnings targets. And that's what we would refer to today as real earnings management. These are real decisions that generate real revenue. It's something that General Electric and other companies did for decades in meeting projections and so forth. And unless it's linked to a particular accounting violation, it's fairly rare for that sort of real earnings management to be considered securities fraud. Now, there were a few transactions that were questionable. There were the sale of the Six Flags amusement park to a partnership of investors where the partnership never took on the risk of loss with respect to that particular asset. And the accounting professor Abraham Brilloff wrote a Barron's article that explained how the effect of the sale was to ensure that Penn Central would report a profit rather than a loss in a quarter where the CEO had predicted the company would deliver strong results. So that looks a little bit more like a modern securities fraud, and that's sort of what Enron did in a number of transactions. They sold assets like barges in Nigeria to a special purpose vehicle without transferring the risk in order to meet various earnings projections. So this case, in my view, marked a very significant development for the SEC, and it preceded a number of other major efforts, which I think were mostly squarely within the SEC's authority. The case against equity funding, which is in Century City, 2-minute drive from where I'm sitting today. They basically made up insurance policies, or they made up insurance policy sales in order to boost their revenue and earnings. And there were a good number of accounting frauds around this time. And so the SEC's enforcement division was just getting off the ground at this time. It was formed in 1972. It generally interpreted its authority pretty aggressively, and that's sort of where Roberta came in. She was critical of these efforts and was famous for doing so. In 1979, the New York Times published an article about one of her dissents in the Spartech matter. This also involved an SEC report of investigation, like the Penn Central report. Spartech was a tile company located in Canton, Ohio. It had a controlling shareholder, and the controlling shareholder wanted to sell the company, all of its assets, to another company. And it came up with a proxy statement, a preliminary proxy statement that didn't disclose all of the particular ways the controlling shareholder would benefit from the transaction. And this is what sparked the SEC's interest. The problem, though, was at the time, the SEC did not have the power to bring an administrative proceeding for violations of Section 14 of the Securities Exchange Act of 1934, which was problematic if you're challenging a misleading proxy statement. And so what it did, at least as what I can sort of glean from rereading the decision, is that it brought an administrative proceeding based on a very minor violation of Section 13 of the Exchange Act, which it had authority to do. And the violation alleged that they should have filed an 8K in announcing the transaction. And they simultaneously file an SEC report of investigation on the Section 14 violations. And it was really the Section 14 violation. Anyone reading the decision today would know that that was the conduct they were trying to question. That was what justified the SEC's remedy, which was to appoint a special review person who was supposed to look out for the interests of the minority shareholders. A very strong sort of corporate governance type of remedy. I'll let Donna talk much more about remedies and the scope of remedies, but this is sort of an interesting example of a aggressive remedy. And the SEC was doing a lot of this during this time, trying to regulate corporate governance. And Roberta was critical. She was critical of the SEC's action because, in her view, a report of investigation should not be used to justify a sanction, particularly a sanction that extended the SEC's jurisdiction. In her view, the proper course of action would have been for the SEC to ask Congress for the power to bring these sorts of cases, rather than bringing the enforcement case now. By stretching its power, there are a couple of problems that Roberta highlights. One is the SEC sort of reduces its legitimacy, its reputation for fairness. And secondly, there are due process considerations for companies that are sanctioned in a way that they may not have anticipated. And this is essentially Roberta's famous regulation by prosecution critique. I thought of Roberta's critique recently when I was looking at initial coin offerings, ICOs, which were sort of booming a few years ago. Basically, these were digital tokens that were sold in order to finance various projects relating to blockchain technology. And for some time, there was significant ambiguity as to whether the SEC considered these tokens to be securities. Bitcoin, as you know, is sort of the pioneer, and the SEC has generally concluded it is not a security, it's more like a commodity. And the interesting thing about the efforts here is that the first major action the SEC took with respect to initial coin offerings came in the form of an SEC report of investigation. So what happened in the DAO case? DAO stands for Decentralized Autonomous Organizations. And the basic idea behind the DAO was that it was an investment fund that was going to invest in other blockchain projects. And if you bought a DAO token, you got the right to the profits. And interestingly, you also got the right to vote on the projects that the DAO fund would invest in. And the reason they structured it, one of the reasons they structured it like this, is the Howey test. The Howey test basically says that a security, an investment contract, requires that the expected profits are coming mainly from the efforts of others, mainly from the efforts of other individuals. And if you're voting on the projects, then the investors are also participating in the endeavor, which might make it fall outside of the definition of a security. The problem, though, was that the DAO founders were doing some work in screening the projects that would be voted on. They were selecting the projects that would go up for a vote. And the SEC basically says in the DAO report of investigation that basically transformed this into a security because those were the undeniably important efforts. And I think that's a reasonable conclusion. It is an important part of sort of the selection of the investments. But I also think just as easily a court could have concluded that this is more like a partnership between the investors and so forth. So I thought this is a very close case. Now, I've been generally supportive of what the SEC has done with ICOs. I think they've done a very good job in a very challenging environment that was moving very quickly. But here is where I think they might have gone a little bit astray, is that they're citing the DAO report all over the place. And they're citing it in a way to imply that because of the Dow report, you should have known that your token was a security, and therefore you should be punished more. And this is kind of an example in the Kik case, which I think is still being litigated, where the SEC kind of makes this point. And this to me is very problematic. The Dow case was a very close one. It left a whole lot of questions open. It's not a court decision, right? It's just the ruling of an administrative agency. And while I think that it was right for the SEC to crack down on these initial coin offerings, should not be implying that its Dow decision established some clear law in this area. Just to conclude and wrap things up, the Dow report to me shows how Roberta's work has had staying power. Her critique of SEC reports of investigation, her broader warnings about the dangers of regulation by prosecution are still relevant today. And I think this is an argument that is going to be raised decades and decades into the future. And she's the one who came up with this framework that we're all using to look at these questions. Thank you, Roberta.
Thank you so much, Jim. And now we're gonna, great. We're now gonna turn to Professor Donna Nagy. And Donna, do you, I think you also are sharing slides as well, is that correct?
Yes, let me try that.
All right, the beauty of Zoom. Great.
How's that? Excellent. Well, I am tremendously honored to be a paper presenter at this symposium celebrating Roberta and her influential scholarship, her dedicated teaching, and her outstanding leadership. I had the pleasure of meeting Roberta nearly 25 years ago when she kindly participated in a securities law conference I organized as a junior faculty member. At that time, I was already well familiar with Roberta's trailblazing career. I was also a huge admirer of her book, Regulation by Prosecution. As Marianne was summarizing for us the wonderful book, the profound influence that Roberta's words had on my own thinking early in my career came right to mind. So I want to thank Roberta here at the outset. You were an inspiration to me then, and I have been truly privileged to have you as a mentor and a friend in the decades that followed. So my talk today is going to be devoted to SEC enforcement remedies past and present. I'll be focusing on court-ordered SEC disgorgement, both as a long-standing equitable remedy and now in the wake of very recent congressional legislation as an express statutory remedy. Defendants in securities law cases collectively pay billions of dollars each year in SEC disgorgement, so the status of the remedy is an issue of great significance. Now, as it happens, a few years ago in a law review symposium commemorating the 50th anniversary of the Second Circuit's decision in the Texas Gulf sulfur case, Roberta and I each authored separate essays on the topic of SEC disgorgement. As most of you know, in addition to being a landmark decision in the areas of insider trading and corporate disclosure, the Texas Gulf litigation constituted the very first occasion on which a court ordered securities law wrongdoers to turn over to the SEC their ill-gotten gain. From the Second Circuit's Texas Gulf decision in 1971 until 2017, when the Supreme Court addressed the disgorgement remedy in the case Kokash versus SEC, the statutory authority of SEC disgorgement stood largely unchallenged. But the disgorgement landscape changed radically in the wake of the Kokash decision. And the disgorgement remedy has been on a fast-paced, well, shall we say, roller coaster ever since. So this disgorgement roller coaster has had two recent twists. The first occurred last summer when the Supreme Court decided Liu versus SEC. Now, the court in Liu ruled that district courts could issue disgorgement orders under Section 21D5 of the Exchange Act, which authorizes equitable relief for the benefit of investors. Congress included that provision in the Sarbanes-Oxley Act of 2002. The second disgorgement twist occurred this past January, when Congress added a new Section 21D7 to the Exchange Act. That section expressly authorizes the SEC to seek and federal courts to order disgorgement in any SEC action. This recent legislation also sets out an express statute of limitations for SEC disgorgement. Now, those are not provisions one would expect to find in the mix of hundreds of pages related to Defense Department appropriations, but there you have it. So back in 2018, Roberta and I reached similar conclusions. That is, we each contended that court-ordered disgorgement was a long-standing equitable remedy in properly instituted SEC enforcement actions. I made that same argument in an amicus brief I filed on behalf of a group of law professors prior to the Supreme Court oral argument in lieu. But notwithstanding the court's decision in lieu, and notwithstanding the even more recent congressional legislation marking disgorgement as an express remedy, there is a significant amount of analytical work that still needs doing. And I hope to highlight some of that work today. Specifically, I have 4 principal reasons for continuing to explore disgorgement specifically and equitable remedies in general. Now, first, tens of billions of dollars in court-ordered SEC disgorgement were awarded in the 3 decades between the Second Circuit's Texas Gulf Sulphur decision in '71 and the Sarbanes-Oxley Act in 2002. So the legal authority that justified those awards should continue to matter. I don't see it as simply water under the bridge. Second, the lieu court's narrow interpretation of Section 21D5 substantially constrains the type of equitable relief that a court may order. So it's important to SEC enforcement that the provision isn't viewed as the exclusive source of a court's equitable power. And in any event, equitable relief under Section 21D5 is authorized only in the context of SEC enforcement actions. So it's important for all plaintiffs, whether the SEC or private litigants, to be able to draw upon a federal court's equitable authority outside the context of 21D5. So third, for reasons I'll explore toward the end of my talk, SEC officials, defendants, courts, they're all in for a tough road ahead when they begin to apply the statutory text in Section 21D7's express disgorgement provision. In fact, Congress amended the Exchange Act so that it now curiously contains 2 distinct provisions authorizing the imposition of disgorgement. It also specified a limitations period for disgorgement, which is separate and distinct from the new statute of limitations for equitable remedies. So if you're scratching your head right now saying, wait a minute, I thought disgorgement was an equitable remedy, you are hardly alone in struggling with these new congressional puzzles. And fourth and finally, I think there's a very important object lesson that can be drawn from the disgorgement roller coaster over the last few years. Namely, by the end of my talk, I hope to have you convinced that it's unreasonable for the Supreme Court to demand that equitable remedies be codified explicitly in federal statutes for purposes of determining the relief that a federal court may award to an enforcement agency such as the SEC. In fact, long ago, the Supreme Court recognized a presumption that Congress intended broad equitable powers on the part of federal courts in agency enforcement actions absent evidence in a statute to the contrary. To be sure, the FTC was not successful in arguing for ancillary equitable relief on the part of courts in an FTC enforcement case to reach the Supreme Court this term. And that also involved court-ordered disgorgement and restitution. But as a unanimous Supreme Court observed just last month, the Federal Trade Commission Act has particular provisions that arguably can be read to limit a court's jurisdiction in equity. The text and structure of the federal securities laws, on the other hand, contain no such limitation. So it's my view that the SEC would be on solid ground when it seeks a more flexible approach to the recognition of court-ordered equitable remedies. Now, I want to focus first on Congress and the federal securities laws, and I want to go back in time to 1977 when Roberta was an SEC commissioner. At that time, and indeed dating back to 1934, the statutory landscape for SEC enforcement remedies differed significantly from the vast array of remedies that the SEC can seek today. Section 21D1 of the Exchange Act authorizes the SEC to seek court-ordered injunctions, and Section 27A of the Exchange Act specifies that U.S. district courts shall have jurisdiction over all suits in equity and actions at law brought to enforce Exchange Act liabilities or duties. Now, the Securities Act of 1933, the Investment Company Act of 40, the Investment Advisors Act of 40, all contain mirror image provisions authorizing injunctive relief and according jurisdiction over all suits in equity and actions at law. So when the Second Circuit in 1971 affirmed an order requiring the insider trading defendants in Texas Gulf to disgorge their ill-gotten gains, the Second Circuit situated the disgorgement remedy in the general equity powers that Congress conferred upon district courts and evidenced in the jurisdictional provisions of the federal securities laws. So Congress in the 1980s, in the 1990s, in the early 2000s added new express statutory remedies to complement and supplement the injunctions and ancillary equitable relief that courts had been ordering. But the congressional design of each newly added enforcement tool was predicated on the availability of court-ordered disgorgement as an equitable remedy. For example, in the Insider Trading Sanctions Act of 1984, Congress for the first time authorized the SEC to seek court-ordered monetary penalties of up to 3 times profit made or loss avoided by the insider trader or tipper. Injunctions and disgorgement were viewed by Congress as inadequate deterrents because the return of unlawful profits merely restores a defendant to his original position. In contrast, the possibility of a 3-time sanction extracted a real penalty, in Congress's words, at least in the legislative history, for such illegal behavior. In 1990, in the Remedies Act, Congress expanded the civil monetary penalty remedies to extend to virtually any violation of the federal securities laws. So monetary penalties were no longer limited to insider trading cases. The Remedies Act in 1990 also authorized the SEC itself to order disgorgement as a remedy in administrative proceedings. And then comes 2002 in the Sarbanes-Oxley Act. Congress added Section 21D5 to the Exchange Act, which, as I mentioned at the outset, authorizes the SEC and federal courts to order equitable relief for the benefit of investors. Now, the committee report accompanying the Sarbanes-Oxley Act reveals that this provision was intended to allow the SEC to obtain additional relief beyond traditional disgorgement. Against the backdrop of Enron WorldCom scandals, the intent was to allow courts in appropriate cases to order corporate executives to return bonuses or raises that they earned when the company itself was violating the federal securities laws, even if the executive individually did not engage in wrongdoing. It is sadly ironic that Congress's attempt to broaden SEC remedies by Section 21D5 has been incorrectly construed as a congressional decision to limit SEC remedies. So now I want to move from Congress to the Supreme Court. In its 2007 decision in COCAS versus SEC, the Supreme Court ruled that SEC disgorgement constituted a penalty for statute of limitation purposes. After emphasizing that the disgorgement awarded to the SEC in that case was directed to the US Treasury rather than to injured investors, the court concluded that disgorgement that was ordered bears all the hallmarks of a penalty. It was imposed as a consequence for violating a public law, and it was intended to deter, not to compensate. But just 3 years later, in the June 2020 decision in Liu versus SEC, Justice Sotomayor's view of disgorgement was strikingly different. Based on the text of the equitable relief provision in Section 21d(5) and what the court described as traditional equitable practice, the Liu court effectively placed 3 preconditions on disgorgement under the provision. The SEC is required to return defendants' gains to wronged investors for their benefit, no joint and several liability, and third, illegal gains are net gains, all legitimate expenses must be deducted. The contrast between the 2 opinions is striking. The Kokash decision referenced the disgorgement rationale, referenced deterrence as the disgorgement rationale, a total of 15 times. And the Kokash court emphasized that the violation at issue was for a public harm. The word deterrence appears nowhere in the Liu decisions, nor is there an emphasis on public harm. In the 2 decisions, the court seems to have in mind 2 very different types of disgorgement. The disgorgement penalty analyzed in Kokash that is sought for deterrence purposes for violations of public harm when the funds go to the US Treasury, and the equitable disgorgement addressed in Liu, which the court viewed as a compensatory remedy to benefit investor victims as provided for in Section 21d(5). But here's one more relatively recent Supreme Court case that stands in tension with both Kokash and Liu. In 2015, the Supreme Court itself ordered the equitable remedy of disgorgement in Kansas versus Nebraska, which was a water law dispute in which the court exercised original jurisdiction to award disgorgement in addition to compensatory damages as a means of deterring Nebraska from violating public law in future instances. The Kansas decision is particularly important because in bolstering its own authority for imposing the disgorgement remedy, the court seized upon precedents in agency enforcement actions where federal courts would have the breadth and the flexibility of equitable powers in the particular context of those enforcement actions. The Kansas decision clearly relied on the 1946 precedent in Porter versus Werner Holdings to draw a distinction between equitable remedies in public enforcement and equitable remedies in private actions between private parties. Justice Sotomayor's curious approach to disgorgement in the Liu case may well have been a function of a strategy set out in the Solicitor General merits brief during the last year of the Trump administration when Noel Francisco was Solicitor General. The brief advised the court that it needn't decide whether the Second Circuit in Texas Gulf Sulphur and hundreds of other cases since had justifiably awarded disgorgement prior to the Sarbanes-Oxley Act in 2002. Instead, the brief put all its eggs in the Section 21d(5) basket. That is, the government urged the court simply to interpret the words of any equitable relief in Section 21d(5), and it argued that any equitable relief clearly includes disgorgement as obtained by the SEC. Justice Sotomayor's majority opinion in Liu took up the government's invitation and focused on Section 21d(5) like a laser. The court took no notice of the jurisdictional provisions in the federal securities laws, and there was nary a reference to inherent equitable powers on federal courts. But in Supreme Court advocacy, as in life in general, one needs to be careful what one wishes for. Justice Sotomayor gave effect to the entire provision in Section 21D5 and essentially construed it to authorize only gains of restitutionary relief. In her view, the statutory phrase benefit of investors was intended by Congress to constrain SEC relief. Otherwise, in her view, the court would be ignoring what she construed as an investor benefit limitation. But tying all court equitable relief in SEC enforcement actions to only awards benefiting particular investors would impose a huge limitation on court-ordered equitable remedies. For starters, not all victims from securities law violations are investors. Often victims are instead market participants, securities firms, or the general public. Courts also use their equitable power to grant the SEC a vast array of non-monetary remedies. And private plaintiffs often seek injunction in federal securities law cases. My paper argues that the statutory source of that equitable power is the jurisdictional provisions of the federal securities laws, as the Second Circuit rightly observed in Texas Gulf Sulphur more than 50 years ago. So I began with Congress and the text of the securities law, and I'm going to end the talk this same way by turning to the now very recent provisions relating to SEC disgorgement. Once again, Congress has muddied the waters with inartful and confusing statutory language. We have on one hand a new section 21D7, which simply authorizes the SEC to seek and any federal court to order disgorgement. But curiously, disgorgement is also authorized in Exchange Act section 21D3A, which provides that in addition to imposing a civil penalty for an Exchange Act violation, a court may require disgorgement under paragraph 7 of any unjust enrichment as a result of the violation. Precisely how the narrower provision in D3A relates to the broader provision in D7 is puzzling. That is, under its plain text, disgorgement pursuant to D3A is available as a remedy only when the SEC has instituted an Exchange Act penalty case not involving insider trading. So in Securities Act, Investment Act cases, Investment Company Act cases, or in insider trading cases, the only applicable express disgorgement provision is the one in D7. But as you can see from the plain text, that provision makes no reference to unjust enrichment, nor does it contain any restriction on as a result of the violation. The legislative drafting for the express statute of limitations is equally perplexing. The D8A provision imposes a 5-year limitation on SEC disgorgement unless the violation involved fraud, and that triggers 10 years. The D8B provision provides for a 10-year limitation period for SEC claims for an equitable remedy, including an injunction. Congress's decision to separate out the time clock for disgorgement claims from the time clock for equitable remedy has prompted at least one scholar, Notre Dame's Sam Bray, to conclude that now disgorgement is no longer an equitable remedy. According to Professor Bray, disgorgement awarded to the SEC is akin to legal restitution, which he argued is outside of Liu versus SEC entirely. My own view is that Professor Bray is reading way too much into the statute of limitations provisions. Now, I've not yet had a chance to discuss with Roberta her own reaction to the Supreme Court's decision in the Liu case, and I'm greatly looking forward to talking with her about how she would begin to solve the disgorgement remedy puzzle that Congress constructed on the fly in the final days of the Trump administration. So I'll end my talk as I began, with an enormous thank you to Roberta for her generosity and support of my work for more than a quarter of a century, and with much eagerness for the ideas we'll be sharing with each other down the road.
Wonderful.
Thank you so much.
Thank you so much. That was wonderful. All right, now we have with us today, as I said, we are particularly lucky. in that we have now two practitioners who are former directors of the SEC's Division of Enforcement, who now have can react to both. We've had one presentation sort of looking at, here this old story of fraud and different types of fraud, and how does the SEC respond to it? And also, as Professor Park also said, how does it respond to something new like Bitcoin and blockchain? And then we have actually something quite different, which is this problem that I think Professor Nagy surfaces a new problem, which is and maybe a new villain, which is when we have congressional statutes that I guess I'll say in my folksy way seem not to make a lot of sense. And so with all of that said, then I'm going to turn it to first Richard Walker, and then after that to Linda Chapman Thompson. Richard, you want to take the reins from me now?
Thank you very much, Miriam, and thanks to all that have made this program possible, and for including me among the other very strong speakers here. It states the obvious to say that Roberta is a woman of strong, well-informed views and strong principles. I want to start with two quick stories about Roberta that I think help inform our discussion today about her views on enforcement, and just how important those views are, particularly important today in the current climate. I think both of these stories will show the rigors of her jurisprudence, and they will also carry a strong message about the importance of bringing a skeptical eye to enforcement cases, questioning very closely the authorities on which they're based and the process that was used to achieve them, particularly in times where there are strong political or personal or popular pressures to take actions that may not be well grounded or may exceed the scope of an agency's authority. First story regards my own interactions with Roberta. And I first met Roberta after I joined the SEC in 1991. I was the regional administrator and then regional director of the New York regional office. And I met Roberta basically through CLE programs that were sponsored by various organizations, and in particular, the annual SEC Speaks program, which was a program once a year when the SEC staff had opportunities to discuss their various programs. Each of the divisions was given an hour or so to discuss what they were doing. And on each of the programs, a former commissioner was invited to act as a monitor. Most of the commentators, I said moderator, I meant commentator. Most of the moderators were fairly passive, not Roberta. She always engaged the staff, and she always had questions about some of their work, the cases that they brought when she was on enforcement panels, positions that they were taking. And I remember in particular her questioning when I was general counsel, questioning the general counsel panel about one of our very controversial Rule 102E cases. I think it might have even been Rule 2E then. As many of you know, Roberta has long had concerns about the SEC's efforts to sanction lawyers and accountants under its rule governing its authority to sanction people that are professionals appearing before the commission. So another year, she was the commentator on an enforcement panel, and I had become enforcement director by that time. She was equally active. I have to confess, Roberta, that I chafed somewhat at your questioning about the basis of our cases and some of the positions that we took. But particularly in hindsight, and after reading again Roberta's book before this panel, I suspect I probably fit the description that she has in her book about enforcement staff pretty well. I was aggressive, somewhat moralistic, and pretty hard charging. And in fairness, this is a description that Roberta attributes to herself because she started her SEC career as a staff attorney in the New York office on the enforcement side. Now, for me, over the years, my roles have changed, and I found myself on the other side of the table. And I've really gained much greater appreciation for some of the concerns about the enforcement process that Roberta championed as a commissioner. And again, while rereading parts of her book, I came across a prophetic passage that certainly rang true from my own experience. And Roberta noted in the book that she dissented vigorously and frequently, her words, from commission decisions. But she went on to say, and this is a quote, "However, I believe my views are not as controversial as they were then perceived, and that eventually they will be better understood and hopefully even accepted." And I can say from a personal point of view that I now have a much greater appreciation, Roberta, for what I will call your conservatism in approaching regulation, though I still have a lot of enforcement blood running through my veins. So quickly, my second story is one that's been passed down over the years among SEC staff, who often share stories about forebears, such as distinguished forebears such as Roberta. And these stories tend to enrich our experience as a staff person and our shared history. And for this story, I had to call quickly my great friend Bill McLucas, who was actually on the staff in enforcement when Roberta was a commissioner, because I wanted to make sure I got the facts checked and straight. And so Bill was a terrific help. And Bill sets the stage by taking us back to the late 70s, shortly after Roberta was appointed commissioner in 1977. Harold Williams was the chairman. The other commissioners included Irv Pollack, who was, of course, a very beloved former staff member who was the first head of enforcement. And before that, the director of the Division of Trading and Markets. Enforcement was sort of spun off from that division. In addition was another former staff person, Phil Lewis, who was a very distinguished commissioner, general counsel of the agency. And finally, John Evans, who was a former top aide to Senator Jake Garn. And by 1977, the well-known foreign payments program was winding down that had been spearheaded by then Enforcement Director Stanley Sporkin. And the FCPA was in fact passed in December of 1977. And while the pendulum had already begun to swing back in favor of deregulation under the Reagan administration, nevertheless, the power of Stanley Sporkin was at its peak. He was an extremely powerful, perhaps the most powerful staff person in the history of the agency. In addition, of course, he was probably the most feared person in corporate America, largely because of his successes in focusing on excesses in the corporate sector and bringing them to heel. And while his enforcement program was highly successful and lauded by the likes of Senator William Proxmire, I think in fairness, some of the positions he took and the settlement demands that he made were extremely aggressive and probably perhaps outside the parameters of the authority that existed. But he had enormous power within the SEC, and the commissioners usually lined up behind him. Enter Roberta. Early on, she spoke up, and she was skeptical about some of the positions that enforcement was taking. And she voiced her opinion that they were stretching the law where it was appropriate, or bullying companies and individuals into settlements that probably weren't well-founded, or without due process and fundamental fairness. Often, she stood alone in her views. So Roberta describes in her book how the former commission headquarters at 500 North Capitol, there was a room for enforcement recommendations to be considered. It was always called during my era the closed commission meeting room. And as she describes it, there was a crescent-shaped table where the commission sat, Roberta to the far right because of her seniority. And then across from the commission directly was a crescent-shaped table facing the commission directly, so that there was a robust dialogue about the recommendations. And so Roberta sat on the right, Stanley Sporkin sat on the right. They were approximately 6 feet socially distanced from each other before that term originated, but they were separated by a pillar. And that was a problem, because as Bill tells the story, closed meetings were often very tense, with Roberta asking a lot of pointed questions about some of Stanley Sporkin's recommendations. Stanley wasn't accustomed to having his authority challenged in this way. And so when the dialogue would occur, when Roberta would ask questions, Stanley would either try to lean forward to look at Roberta, which he couldn't do because there was a pillar in the way, or he would turn his head to the right and talk to the pillar. And so then when Stanley stopped speaking, Roberta sort of did the same thing. She would have to talk to the pillar, raise her questions. And in hindsight, this may sound comical, but Bill tells me at the time, it definitely was not. It was tense. That some of the dialogue was a bit tart. And frankly, in my experience, it sounds unprecedented. I can't imagine a situation, I was never during my tenure, where a lowly staff person would have, run the risk of really talking sharply to a commissioner who was appointed by the president and confirmed by Congress. But the position in which she found herself as a chairman no doubt fueled her lifelong skepticism about some of the potential excesses of enforcement, and her dedicated efforts to make sure the process and the cases were unquestionably well-grounded and regulatory authority existed and the process was fair. So with that as a prologue, I'd like to just spend a few minutes talking a bit about the core concept of regulation by prosecution, or as we used to just call it, regulation by enforcement. And I think Linda will agree from her time as enforcement director, regulation by enforcement was a claim that was raised very frequently in investigations when attorneys for subjects of the investigation would come in and claim we were acting excessively. It often wasn't very well parsed, but really just raised as a general objection to the bringing of a case. But as I think of the concept of regulation by enforcement, I think there are several distinct categories that need to be identified. And probably the first category that can fairly be characterized as regulation by enforcement are cases where there is really no direct regulation, no statute, no rule. And the SEC brings an action under the rubric of whether it's 10b-5, which is the commission uses very broadly, or some other statute. And this, of course, is the story of insider trading. There never has been a direct law or statute prohibiting or even defining insider trading. Now, grant you that there are exceptions to what I just said. Of course, there's a rule prohibiting insider trading in tender offers. There's Rule 10b-5-1 and 10b-5-2, and it was previously mentioned by Professor Nagy. There are penalty provisions that identify insider trading, but there's never been a statute that prohibits insider trading head on. And yet the SEC has succeeded in bringing cases over the years under its broad authority under Section 10b and Rule 10b-5. And basically the law of insider trading has developed by SEC wins and SEC losses. More often wins, to be honest, but they've had some losses as well. I mean, the Dirks case certainly was a large loss for the SEC in the Supreme Court. Interestingly, the SEC has historically eschewed seeking authority to proceed in this area, though there have been several steps in that direction initiated by others. The first of which was 1988, when Harvey Pitt, former SEC general counsel and future chairman, and several other practitioners were asked to draft a bill by Congressman Regal, and that bill was introduced into both the House and the Senate, but got nowhere. When I was general counsel in 1988, and the O'Hagan case, I think 1997 actually, and the O'Hagan case challenged the SEC's misappropriation theory of insider trading, was pending in the Supreme Court. I was asked to review the 1988 draft legislation and be prepared to send draft legislation up to the Hill pretty quickly in the event that the commission lost O'Hagan in the Supreme Court and the commissioners decided to seek to have corrective legislation adopted. Happily, the commission won that case and there was no need for legislation. More recently, there have been some adverse case law for the government by lower courts involving the required benefit under the Dirks case for tipping liability, which prompted former United States Attorney for the Southern District of New York, Preet Bharara, to form a task force consisting of a very prominent judge, Jed Rakoff, I think Jack Coffey, who's going to be speaking later, and some other very distinguished people to make some recommendations regarding insider trading. And not surprisingly, the task force recommended legislation be passed that prohibited insider trading. And of course, even before that task force had issued its report, there were several bills working their way through Congress that were already in the works. The commission, on the other hand, while no doubt providing some technical assistance, as it's called, to Congress on the various draft bills, appears to continue to prefer the great flexibility that they've always had under 10b-5, as opposed to a hard and fast set of rules governing insider trading. And in fairness, this is a flexibility that for the most part has served them pretty well over the years in developing the law around insider trading. And not surprisingly, as recently as 2015, Roberta weighed in and wrote that the SEC should definitely advocate legislation and that there should be a set of well-defined principles governing insider trading prohibitions. So another area that has been mentioned earlier where the SEC has taken an aggressive approach in bringing cases where there's no direct regulation or statute is the area of digital assets and cryptocurrencies. And the rise of Bitcoin and other cryptocurrencies and assets has heralded the emergence of an entirely new asset class and has posed one of the greatest challenges to regulators in the past 50 years. Once again, the SEC has relied on its historical authorities, Section 5, fraud statutes, and has actually expressly turned down an invitation by Congress, the Senate Banking Committee, to seek additional authority to regulate this asset class in favor of a step-by-step incremental approach. There have been some hard-fought clashes between the SEC and the CFTC on the one hand, and various coin and token operators on the other regarding whether offerings need to be registered, whether they're securities offerings, or whether they're without SEC jurisdiction. And in terms of regulation by enforcement, the SEC has laid out in its cases and its settlements principles that it believes apply. But nevertheless, there's a very fine line in assessing these cases. These currencies are new, they differ from one from the other, and the law is quite unclear. And perhaps no case has generated more controversy than the SEC's recently filed case brought late last December, when everybody was sort of clearing out. The Chairman Clayton was leaving, the two enforcement directors were leaving. They launched the Ripple case based on its sale of a cryptocurrency XRP, which they alleged did not follow SEC offering rules. And this is going to be a case that's very, very closely watched by all. Ripple had been openly engaged in the sale of XRP cryptocurrency for 8 years when the SEC filed suit. Ripple claims that the SEC guidance over that period was confusing, was contradictory, and didn't address XRP. What makes this case even more interesting to watch is that Ripple is represented by the former SEC Chair Mary Jo White and former Enforcement Director Andrew Serezny. And the rumor is that Professor Joe Grunfest, a former SEC commissioner, wrote to Chairman Clayton and told him it would be a huge disaster to bring this case and very damaging to investors. And one can only wonder which side Roberta would have taken in this action and what she might have said at a closed commission meeting at which the case was authorized. I think we all have a pretty good idea where she might have come out on that. Well, insider trading cases and cases involving digital assets often lead to contentious litigation. The vast majority of SEC cases are settled. And settled cases in areas where regulatory authority is either non-existent or murky are in some respects the most troublesome types of cases where when you're talking about regulation or settlement, regulation by settlement or regulation by enforcement. Without question, the SEC has enormous leverage when dealing with companies and individuals accused of wrongdoing. Many of them lack the resources to stand up, to fight, and they often have concerns, legitimate concerns about the collateral consequences of a fight with the SEC. So I think it's this area where regulation occurs not by enforcement, but by settlement, where the SEC has enormous leverage and the ability to bully its subjects into submission and to spell out its theories of liability in unchallenged settlement agreements, which then become the baseline for all future settlements. Regulation by settlement was a matter of great concern to Roberta, and rightfully so. So another twist on the notion of regulation by settlement is the practice of taking undertakings from settling parties to settle actions. An example of this is the settled Tesla case, where the SEC required Tesla to undertake in a settlement to make vast corporate governance changes, to depose or dethrone Elon Musk, to hire a securities lawyer, and to cause other things to be done as the price of settling the case. While SEC settlements do not serve as precedent in litigated actions, which courts are obliged to follow, they nevertheless are a roadmap of the Commission's views, which cannot easily be overcome when you're trying to resolve a case or proceeding. So one final area where there's a risk of what Roberta might describe as regulation by enforcement or prosecution is when the SEC passes a new rule, the contours of which are not well defined, or seeks to address an evolving market development using dated guidance that isn't squarely applicable. The risk here is that the SEC forces settlements, and the settlements set the standard for the rule without rulemaking, without legislation, or without definitive court rulings by Article III courts. So there are just two brief areas involving the current matters where I believe that there's a real serious risk of this happening, or at least that we will be hearing that, that this is happening, whether it happens or not. And the first is in the enforcement of the Commission's rule Reg BI, or Reg Best Interest. Reg BI requires broker-dealers to only recommend financial products that are in their customers' best interests, and to clearly identify any potential conflicts of interest in financial settlements. So Reg BI was a very labored birth for the SEC. It took years. There was a lot of opposition by people who believed that a strict fiduciary duty standard should apply across different investment areas. The term best interest itself is not defined, and there have been no enforcement cases involving the rule of which I'm aware. But there is mounting pressure on the SEC to take action enforcing the rule, and it's a safe bet that we'll all begin to see the first Reg BI cases pretty soon. Will the Commission attempt to provide further guidance of what best interest really means? For example, through the Division of Examinations, issuing perhaps a risk alert of what they've been seeing in examinations before they bring enforcement actions? Or will the Commission set forth the standards for broker-dealers to act and what constitutes best interest through forced settlements, in which the Commission gets to write the rules with a free pen in settlement agreements? Don't know the answer here, but I suspect we will all find out very soon. And the final area that will be interesting to watch is how the SEC handles its approach to ESG disclosures. This is an area where public and political pressure is intense, and the SEC has an enormous opportunity to create meaningful change through regulation, adopting clear standards for issuer disclosure. But the earlier signs are that ESG disclosure may be addressed not through regulation, but through enforcement. You have to go back to 2010 to find any guidance regarding ESG disclosure. In 2010, the SEC issued climate change guidance, clarifying how existing guidance may require public companies to describe climate change matters. And that's as far as the SEC took climate change until now. A GAO study in 2018 found that in industries affected by climate change, the SEC issued only 14 comment letters out of 41,000 during a 3.5-year period. Fast forward to this year, and the SEC's agenda seems to be all ESG all the time. On February 24th of this year, Acting Chairman Lee directed CorpFin to review existing 2010 guidance and to begin updating that guidance as part of its review. She also directed CorpFin to review public company disclosures. And among a flurry of other SEC activity regarding ESG, on March 4th, the Commission announced an enforcement task force focused on climate and ESG matters. So the clouds appear to be gathering in terms of future ESG enforcement actions. including those based on a decade-old disclosure guidance that has been largely ignored over the years. And so with that, I will end and I will just say, Roberta, the commission needs you at this time. Thank you.
Okay, that was fantastic. And now we have Linda Chapman Thompson, who is on our line. And Linda was the first, I believe, the first woman to serve as the director of the Division of Enforcement at the SEC. So now she will share her views. And while she is speaking, I just want to note to the audience, if you have questions, go ahead and fill it in the Q&A, and I'll take a look at that while she is speaking. Go ahead, Linda.
Thank you so much. And apologies for my background. I was somewhat confused about what I was doing. So here I am, but I am not confused on one thing, and that is my deep and profound affection for Roberta. I think I echo what everyone has said. And one of the things I would note, and the stories of Roberta and Stanley Sporkin are indeed legendary, as Dick noted. And the particular one about the pillar, I think I heard that story my first week at the commission and heard it often. And I think all of us have. And that, as has been noted, that skepticism or rigor that Roberta brought to enforcement was sometimes uncomfortable, but always, I think, appreciated and always made for a better result. My experience is a little softer because in addition to Roberta's profound skepticism and principled approach, there was is no one who's a bigger champion of women in this profession and in the securities business and in securities enforcement. So her affection for all of us who followed in her footsteps, her support of us was unwavering and unqualified. And I did not have a better friend to support me in my role in enforcement. And so I just feel this truly profound and deep affection for all that Roberta did, despite the fact that from time to time, her views were challenging to those of us in enforcement. So, and I echo what everyone else has said in that regard. I thought I would spend a little time on rulemaking by enforcement or rulemaking by settlement, as Dick described, rulemaking by law enforcement, and sort of deconstructed in a couple of ways. When I was in the position of division director, we were, as Dick suggested, routinely challenged as we were doing rulemaking by enforcement, to which my response was almost always a flip response: is I can't enforce the law unless someone's broken it. So that's where I start. But one of the things that I think gives some weight to the argument that we're doing rulemaking by enforcement is the notion that we deal with often a deterrable population. And if you think about theories of law enforcement, the best purpose, the highest purpose of law enforcement is deterrence. And I think many would argue general deterrence is the most,
what's going on?
The best objective. And the SEC is, and Division of Enforcement is very lucky to have a deterrable population. People pay attention to what enforcement does, and they modify their conduct accordingly. So to that extent, to the extent people are changing their conduct based on the cases that are brought, you do have, to a certain extent, regulation by enforcement. It's not that it's an inappropriate enforcement action. It is rather that it has functioned well as deterrent. Now, we'll get to the end of that, is that power can be abused. The other thing that Dick did not mention, I don't think, is that whenever we proposed rules, you got the flip argument that the rules were unnecessary. You could instead proceed with an enforcement proceeding because it was easier. You didn't need regulations to address the specific problem. So there there's someone who always had some reason to complain about whatever we were doing. One of the things about rulemaking by enforcement, and something that I think is a positive if used judiciously, is that it's typically easier to address conduct. It's because the conduct is historical, so you don't have to worry about unintended consequences. And it's micro. You have specific conduct that can be specifically addressed, and leaves room for conduct that may be similar but not quite as damaging or detrimental. And that's both a plus and a minus. I think it can, you can be overbroad in the enforcement action, but it can also allow you to address very bad conduct. I mean, most of the time in enforcement actions, you have conduct that people are in agreement should be addressed to some extent or another. One of the cases that tortured me for a while was one where we had terrible conduct that was focusing on military families, and they were clearly being abused, financially abused. It was difficult to articulate the securities law violation, and we did using general statutory language. And there was concern in the building, as shared by the Division of Enforcement, that the industry reaction was going to be negative because it was hard to distinguish between legitimate conduct and illegitimate conduct. And what was pleasing to me at the time was the fact that reaction to the case was uniformly supportive of the case, because we did a good job articulating the facts, and the industry and those reading the case and reading the outcome recognized that we were addressing a serious problem and we're not addressing a wholesale practice. So that leads me to a point that I think we don't talk about enough, which is the issue of prosecutorial discretion or enforcement discretion or settlement discretion. And it matters which cases you bring and which cases you decide not to bring. And it is using that tool that I think we can avoid some of the obvious damage that over-aggressive settlements, over-aggressive law enforcement can generate. And one of the things I worry about when we see times that are fraught with, bring more enforcement actions and whatnot, there's a lot of pressure to bring cases. I think, and Dick would probably agree, some of the hardest decisions you make are not the cases you bring, but the cases you decide not to bring. Because almost always, if you look hard enough, you can find a violation of law that you could bring an action for. And as Dick suggests, when you have a population that is willing to settle cases, as we have in the securities field, you can be overly aggressive with unintended and bad consequences. So that's one of the things that I think we need to worry about and think about, and something that Roberta always worried about. In terms of sort of broad statutory authority and broad statutes, 10B is a great statute from a law enforcement perspective. It does have broad authority, but it's not unique in law enforcement. I mean, I think about mail and wire fraud statutes. There are many criminal statutes that are equally broad and can result in similar abuses, if you want to use that word. But I think, again, we need to focus on training and educating discretion. It's very, very difficult to articulate it and to cabinet it. So that's something to think about. When I think about regulation by enforcement, as I said, we have a deterrable population, so they alter their conduct. So what are the worst cases for law enforcement as opposed to regulation? And I think you start with new conduct, as Dick talked about crypto and whatnot. I think it's fair to use broad statutes to address misconduct if you find it, and to do it with great care. Recently, for example, I've been very impressed with the Commission's use of 21A reports to articulate some of the issues that are being confronted and giving some guidance and allowing for some discussion. I also think that to a certain extent, as I suggested earlier, targeted enforcement actions may increase a dialogue as opposed to sweeping regulations in new areas. Perhaps the worst area to bring enforcement actions are with respect to conduct that has been standard practice for some time, and at some point there's an event where that practice results in harm or unintended consequences, and then bringing an enforcement action on against conduct that has been industry practice or standard practice for some period of time strikes me as especially dangerous and unwarranted. So, it is, I think it's something we're going to continue to worry about. Unlike, I think the Commission is fortunate compared to other law enforcement and other agencies, that it has law enforcement authority as well as regulatory authority. And all the other regulatory divisions act as a buffer, if you will, to the aggressive law enforcement efforts. Although I think it is also the case that you will often find other divisions looking to enforcement to do the work of changing industry practice because of the reaction of the regulated and or the industry that we bring enforcement cases against. So there's a lot of balancing that goes on. And I welcome the kind of thoughtfulness that Roberta has brought, and I wish we could see more of it. So with that, I think I'm going to defer to questions back to you.
All right, thank you. That was wonderful. So I know who I'm going to call on first. This is very easy. She has her hand up. So Roberta, this is your chance to weigh in. Please do.
First, I want to thank everybody who participated in this panel for their very interesting, thoughtful, and complimentary remarks. I really appreciate it. And I don't want to take too much time because I don't want to cut into NAN, which is about international matters. And I've always cared a lot about those. But I would say that all of these presentations are very similar in some ways because they're all about how much leeway the SEC should have in situations where either violations are unclear or uncharted, or the remedies that the SEC is trying to impose are novel. Today, the SEC has many more statutory remedies than it had when I was a commissioner. Even the 21A reports, I think, predated the SEC's cease and desist authority, which they now can exercise. I would just say the following is that although I remain committed to the idea that rulemaking is a better way for the government to proceed than making new law and enforcement cases, I appreciate to an extent I really didn't when I was a commissioner how difficult rulemaking is. And in recent years, particularly, it's become so partisan, and there are so many barriers to good rulemaking put up by partisan differences of opinion at the commission, in the courts, and by industry pressure against any new rules, that I have a little more sympathy for the SEC's frustration in certain areas and its reaction by bringing enforcement cases or trying to get settlements. But still, I think that settlements are problematic in many situations because they only bind the parties to the litigation. They do not and should not serve as general rules for other parties, the way rulemaking does. So I really appreciate all of your nice remarks about me and my ideas. And I would say to Jim Park particularly, you know, I kind of forgot about the 21A report in Penn Central, but at that time, there was also the 21A report about New York City bonds that you might want to take a look at. And I think in both of those situations, you had very big entities that were in a way beyond the ability of the SEC to really deal with in an enforcement case, unlike a case like Spartek, which just involved certain individual players in the securities space, and where the SEC was trying to set forth some rules about the going private phenomenon, which the commission was against. And Donna, I would say you did your usual careful analysis of statutory material that I've come to expect from you. I think some of this was in your amicus brief that you wrote in the Kokesh case, and which I actually wanted to join, but I had already signed up to another amicus brief, and they told me you can't be on two, you have to choose one or the other. So I did not have the opportunity to join your very good brief, which had some of the same ideas that you expressed today. And I want to thank also Dick for his remarks, Linda for her remarks. Yes, I started out as an enforcement attorney, so I've always understood where the enforcement attorneys were coming from, because that's where I started out. So thank you all for this very nice introduction to this conference.
And before you all go, because we do have a few minutes, so Roberta, I had cool little slides that I'm not going to impose on everyone, but I do think it's an interesting theme in your book. You know, there are two themes of interest to me, and I wonder if the panelists, if anyone want to take these. The first theme that emerges a lot in your book is your recognition that the SEC is a political animal. Like that, in other words, it has to have the political, it has to have the public support. And this comes through loud, and that you're worried about that. Your criticism of the SEC is as an insider who loves the SEC staff and is who came from that world, as you say. And I'm looking at page 98. You say the SEC, and this was the end of one of your chapters. So you're ending a chapter with your fantastic flair. You write, it has survived, the SEC has survived by reason of the hard work, intellectual brilliance, and integrity of its commissioners and staff. However, if its energies are not channeled into programs that are politically relevant and acceptable, the SEC's good intentions will not suffice or be in the public interest. So there's this idea, there's this tension there, because of course, I don't think you mean, just do whatever, business wants it to do. And you're very clear about that. But on the other hand, you can't just go it alone either. And it's this recognition of that, I think, that comes through your book. And I wonder if you think that the SEC is any better now at navigating that tension than it was when you were writing in 1982.
No, I think in some ways it is more challenged because of the partisanship that has crept into SEC decision-making, which really was not there when I was a commissioner. I mean, I often disagreed with the other commissioners. We often had split votes, and that went back into history, but this wasn't these were not partisan disputes. You didn't know who was a Democrat, who was a Republican. And that has changed in recent years. And I think that it has put the SEC in a much more difficult position from a political point of view.
Do the others have, Donna, it looks like.
Yeah, I think the part is, so I concur with Roberta's, things have only gotten harder argument. And in addition to the partisanship of the regulated communities and even the protected public, we have a much more partisan judiciary that is looking at SEC rulemaking and interpreting the congressional text and words like the SEC shall consider efficiency and competition, and reading into consideration a de facto cost benefit analysis requirement that then the judiciary applies to strike down SEC rules. And so Roberta's compliment of my close statutory text for disgorgement is I've also looked at the so-called cost benefit analysis requirement, and I don't see the requirement. I see a consideration. And so when you take the increasingly hyper-partisan citizenry and layer on top of that some circuit court decisions that set unattainable bars for rulemaking, one then gets more frustrated and might have to increasingly look to things like enforcement or things like regulation by no action letter, which is something that Roberta actually inspired me to write about 25 years ago. And, you know, the more difficult the judiciary makes it for SEC rulemaking, the more these other outlets have to be actualized.
But is enforcement?
Agree. And I would add in the Supreme Court too.
So is enforcement though anymore? So if Roberta and Donna are saying, look, in this more hyper-polarized partisan world, rulemaking becomes really almost impossible. So then what does that mean though for enforcement? Doesn't that mean a problem for enforcement itself? And because won't enforcement now always be viewed through an incredibly partisan lens?
Well, it's also, and this is Roberta's point about the Supreme Court, it actually seems to be putting the onus on Congress to come up with explicit provisions and to keep amending the federal securities laws. But when Congress does so, the result is oftentimes not what anyone, including Congress, intended. And so we seem to be in a perpetual loop. But Jim probably has a strong view on this as well.
I would just add that, you know, just the increasing power of entrepreneurship and the wealth that's been created, I think that's going to create a lot of political pressure, as Richard was sort of alluding to, not only in the digital asset space, but in other, you know, areas, the SPACs, the direct listings, and that's another political force that is very, very well funded and is cause for concern. I'm not sure what's going to happen over the next few years with respect to this entrepreneurial boom.
Richard, last word. Yep.
I was just going to say one thing that I think is a very important consideration here is that Chevron is at its lowest point probably ever. And so deference to administrative actions and administrative activities is as low as it gets. And this is even after the DC Circuit has so often invalidated actions taken by the SEC. So they are, if you're a litigant and you want to challenge an administrative result or rulemaking or anything, you're going to go right to the DC Circuit because the DC Circuit does not give the SEC much deference, if any. And I think more broadly, Chevron is you know, a concept that's probably had its day, and that I think is a significant factor.
All right. Well, you know, Roberta will take that into account when she writes the next book, no doubt. So I want to thank all of the panelists. This has been tremendous and a great way to start this conference. Just a reminder to all of you, our next panel starts, I believe, in another 10 minutes. And it will be started off by my colleague, Robin Efron. And I also remind you all, for those of you coming to our celebration later tonight, the celebration's at 5:30, and I believe you have to and actually you should come a little earlier, and you don't forget to use, we have a special celebration Zoom link, so be sure to use the other Zoom link. And again, thanks to all, and I am signing off, so thank you again. Great.
Thank you, Marion, and thank you, Roberta.
Welcome back to everyone for our second panel. I'm Robin Efren. I'm one of the directors of the Center for International Business Law, which is, of course, one of Roberta's major achievements here at the law school. We'll say more about that this evening at the celebration, but suffice it to say, it has really been sort of the launching pad of the careers of many of our students and of our faculty, and has been sort of a major intellectual site of the law school as well. So it's really my pleasure to moderate a panel today that touches on some of the more international issues in securities law. So I want to take just a second to introduce our panelists, and then we will get started. So we're going to hear a presentation from Professor Howell Jackson of Harvard on the EU challenge to the SEC, a view from 2021. Professor Jackson is the James S. Reed Jr. Professor of Law at Harvard Law School. He's the author of numerous scholarly articles and is a trustee of the College Retirement Equities Fund, CREF, and affiliated TIAA CREF investment companies. And he was also a law clerk for Justice Thurgood Marshall and practiced law in Washington, D.C. before transitioning to academia. So after that, we're going to have three commentators giving some additional thoughts on the topic. So the first is Edward F. Green, senior counsel at Cleary Gottlieb, which he joined after leaving the SEC, having served as director of the Division of Corporate Finance and then as general counsel. He's also a lecturer in law at Columbia Law School, teaching international securities regulation and issues on global regulatory reform. He also serves as co-director for the program in the Law and Economics of Capital Markets, which is a joint initiative of Columbia Law School and Columbia Business School. Next, we will have Paul Leader, who is of counsel at Miller & Chevalier and also a former director of the SEC's Office of International Affairs. He has practiced in securities enforcement, compliance, and complex litigation for over 30 years. Prior to joining Miller & Chevalier, Mr. Leader was the director of SEC's Office of International Affairs. And before that, he spent more than a decade at the SEC in other positions. Finally, we have Eric Penn, who is the president and CEO of the Investment Company Institute, or ICI. Before joining ICI, Eric was the managing director at Rock Creek Global Advisors, an international economic policy advisory firm based in Washington, and a senior fellow of the Center for Law and Economic Studies at Columbia Law School, where he continues to be an adjunct professor of law. From 2015 to 2019, he was the director of the Office of International Affairs at the CFTC. And before joining the CFTC, he was associate director and head of international regulatory policy at the SEC, where he was recruited in 2011 from academia to assist in the implementation of Dodd-Frank and the G20 reforms. So I'm going to hand it over to Professor Jackson, who will give us the initial presentation. And from there, we'll move into the remarks of each of our commentators. I would also direct all of you to the materials that were distributed, where you can find much more detailed bios of our really esteemed panelists. And as Miriam did in the previous panel, if we have time at the end for a broader conversation, I will be looking for those questions in the Q&A, and I will pose those to our panelists.
Great. Thank you very much, Robin. It's a pleasure to be here. And let me see if I can get my screen going. Excellent. Great. So it's a pleasure to be here, and I want to particularly thank Jim Fanto and Miriam there for organizing this event and inviting me to participate. It's really an amazing set of panels of practitioners and former government officials and legal academics that have been assembled here today, and it's a real tribute to Roberta and her work and her influence. Everyone who has come, and it's a treat to be part of the larger group, and in particular this panel with Ed and Paul and Eric. And so I'm just very happy to be here, and my congratulations to Roberta. My task is to set up the panel and talk a little bit about our prompts. we were given the assignment to react to a series of 4 articles. And they're on international harmonization, but I've added in and beyond, because I think they really go beyond harmonization. I'm also just very personally happy to be reacting to these articles, because others on this panel know Roberta better and work with her in different contexts. I know her personally from panels and engagements like this in a Brooklyn Law School, which I've always enjoyed. But really, I know Roberta best from these articles that are our prompts. And they begin back in 1999, and I'll say a little bit about each of them. But they overlap with a period when I was doing work myself on international financial regulation, an empirical project actually with Eric, my co-author before he became famous. He worked together with me on this stuff. And we were writing about transatlantic securities offerings. And most of the academic work at the time about international securities that I was familiar with was pretty abstract. And it was basically work about regulatory competition, where the model of corporate charters in Delaware and the United States were pretty much exported overseas, and the arguments were rerun with the usual suspects on the usual sides. And that was useful work, but there were very few people who actually knew what was going on overseas and had a detailed knowledge, not just of what the SEC did, but what folks in other jurisdictions, particularly in the European jurisdictions, were doing, and writing in it in a way that was informed theoretically, but also institutionally aware, doctrinally grounded, and sensitive to political economies. That was an incredibly useful work for me and for Eric and for many others. As I was preparing for this, I didn't know the words to describe this, but I now know from Professor Janger's introduction that what I was reacting to was the Brooklyn Law School School of Academics that Roberta was working in, and it was a treat to use these articles. Let me just say a little bit about them. And I guess we were doing show and tell. Everyone else has books. I guess I'm going to be small, but I do have the articles that I can show. I have hard copies that I could share with you. But let me just say a little bit about them. The first one is back from 1999, and it's titled "The Case for a European Securities Commission." And it was written at what might be thought of as the high water mark of the European project, at least in my mind. The euro had just been adopted. People were quite ambitious for what the European Union might accomplish. And what the article offered was a fairly strong case for how something like the SEC might be adopted in Europe and facilitate the creation of an internal market that would be more efficient and a better interlocutor for the SEC, and a better vehicle for generating a strong internal market, which had been a goal for some time with the European Union. And the article was quite mindful of the challenges that this project undertook, the resistance of national authorities and stock exchanges, and variations in market practices. But it was a quite interesting and useful view of what was going on in Europe and how the SEC model might be exported overseas in one way or another. And I remember this article quite well. I would say it's at a moment of when harmonization seems to be possible within the EU. And in certain ways, it anticipates things that happened later on. I mean, there's aspects of centralized authority in the creation of ESMA in 2011. It's not all the way to what Roberta was proposing by any means, but it's definitely in that direction. So interesting to see this foreshadowing of that. And it's also kind of interesting to see, looking backwards, how much of the developments that we think of as, accepted parts of the international financial architecture were kind of not so certain back in 1999. The convergence of accounting standards and the development of IFRS, the building out of the IOSCO initiatives on harmonization of disclosure standards and a workable system of a memorandum of understandings. These were, discussed and encouraged in the paper, but were by no means certain at the time. And, in retrospect of 22 years, it's kind of interesting to see this aspect of international harmonization that Roberta was writing about has come to pass. And, no doubt her writings were helpful and important in that regard. So that's the first of the quartet. The next two shift patterns a little bit. The SEC goes abroad with corporate governance and reform of public company disclosure in the Eurozone in Europe. They have a somewhat a different flavor, and they're really written, I would say, in the shadow of the Sarbanes-Oxley Act. And I particularly like the SEC goes abroad. Because it's actually, in some ways, it's talking about some of the issues that were alluded to in the prior panel about what's the appropriate role of the SEC. Is it a governance and fairness regime, or is it, as it's evolved more accurately, to be a disclosure regime? The Sarbanes-Oxley Act moved in many ways into corporate governance in a way the SEC hadn't been in corporate governance before. But the other thing that it did is it had an extraterritorial application of corporate governance, particularly for European issuers who had chosen to list in the United States when we largely exempted them from our corporate governance rules. And all of a sudden, Sarbanes-Oxley comes along and says, well, we're going to have extraterritorial application. And this, those of us who lived through the era, was a very important development. It was a point of great tension in EU-US relations because this perceived overseas an unfair change of U.S. policy, and the Roche Motel, Hotel California, you can check in but you can't check out, was very much the metaphor of the day, and much effort went into smoothing out these conflicts and working through a reasonable source of accommodations between the U.S. and the EU over the Sarbanes-Oxley reforms here. And to some degree, in the second of these two articles, the reform of public company disclosure in Europe, Roberta moves forward with the story of EU development of the Financial Services Action Plan, which is kind of an effort to continue in the creation of a pan-European market, which didn't work as well as the framers had initially contemplated. And she writes here about the Lamfalussy process and the reforms that followed, which were efforts to kind of complete the creation of a European market, and also to some degree build out the infrastructure on things like auditing standards and others that were necessary to kind of bring the EU more in compliance with the Sarbanes-Oxley expectations. So this is a step forward. It's not so much harmonization as a little bit of SEC bullying overseas, but it's an interesting record of the developments of the mid-2000s, which were memorable for those of us who were working in the field at the time. And I think Roberta does a good job of anyone as kind of telling that story. The final article in the quartet, the EU challenge to the SEC, again moves the clock forward a couple of years. The tensions over Sarbanes-Oxley have subsided, but the relationship between the EU and the SEC has altered in another way. And the challenge that Professor Karmel is describing here is not so much the harmonization of markets around IOSCO standards or an SEC-inspired model of supervision, but rather the task is now ascertaining whether European and other regulatory standards are sufficiently similar to those in the United States to allow them to serve as a form of substituted compliance for US requirements. And she's reacting to a trial balloon that Ethiopia's Kapara and others floated at about the time to accept foreign standards in exchange and broker-dealer regulation. But it's also kind of chronicling what I would say is a move away from harmonization. The work of IOSCO, the work of the evolution of standards internationally has made it possible now to sort of think of systems as being roughly comparable or close enough to allow for cross-border passporting, mutual recognition. But it's really a backing away from harmonization. And in some ways, acceptance of this substitute compliance norm means that the impetus to harmonization has diminished. So this is what I mean by going beyond harmonization. She's really, in these articles, gone from the initial movement towards something that looks very much like the SEC, harmonized around IOSCO standards inspired by the SEC, into a different kind of regime that people were beginning to toy with in 2008, and has been influential in a lot of things that have come thereafter. And so what I want to do now is just talk a little bit about what's happened in the last 15 years since the last article, or 14 years since the last article, and the ways in which Roberta's work kind of, to some degree saw the future. She didn't get everything totally right, or it didn't unfold exactly as we had expected. But there are lots of elements in her analysis that I think are prescient. And let me just say a little bit about all of that. So the first thing, I don't think this will be new to this audience. We did not unify European capital markets around an SEC-like cross-border authority. Actually, it was kind of amusing to me as I was reading over her piece. There was a high-level forum from the EU that came out in June of 2020. So this is something like 21 years after her article. The headline is, "The European Union needs capital markets union now more than ever." And there's a lot in this high-level report. It sounds an awful lot like Roberta's initial article about why it would be a good idea to unify things in Europe, and also pointing out the reasons of political economy that made it so difficult to do. So the project of the Capital Markets Union in the EU is still underway. Lots of reasons for that. One of the reasons is clearly she writes the articles just on the cusp of the financial crisis of 2008. In fact, there's some word about rumblings in the subprime market in the last of the quartet, but these are all pre-global financial crisis articles. And clearly the crisis, its aftermath, particularly its aftermath in the EU with the Eurozone crisis, the problems of the Greek sovereign debt, and related issues, has taken the energy away for much of the last decade from capital markets developments, and the focus has been on the ECB mandate, expanding its missions, and really dealing with systemic risk and bank insolvency issues. Plus, of course, the departure of the EU, the UK from the EU through Brexit has put another work stream on Brussels' table, but also taken away the member of the EU that was most closely associated with the US markets and most likely to push towards a US style regime. All of that has derailed what was contemplated back in 1999. The other thing that I think is important to mention, and Eric's in my work talks a little bit about this, but institutional investors. Roberta talked about pension plans, particularly in her writings, and kind of saw the rise of retirement savings pensions as creating a demand for a cross-European border public market to be funded with those savings. And that was a possibility. I think it turns out the institutional investors found ways to go across the borders without public markets, so direct wholesale linkages between markets, and also the rapid expansion of private equity investments kind of has taken a little bit of the pressure off of public markets and reduced their significance until very recently, both in the United States and Europe. And so I think those factors have kind of diminished the push towards a unified market that, you know, Roberta and many others contemplated. So that didn't kind of work out as expected. The other thing that I think, looking back on the articles, is quite interesting is the absence of China or Asia from the discussion about harmonization. And, you know, China was rising as a trading power in the time of these pieces, but as a financial power, clearly not as much at the time. But if you were writing these articles today, and I sometimes, as I was reading, thinking, well, if Roberta was going to make this a quintet, what would she talk about? And, you know, clearly today you'd have to talk about China. But if you did talk about China, you would talk about Roberta's articles about Sarbanes-Oxley, because if you go to the heart of the US-China conflict, it's the Sarbanes-Oxley conflict. It's a, how does the PCAOB's auditing standards and inspections extend into the PRC? And, you know, that's been a source of huge tension, continuing tension. And now Congress has set a 3-year fuse to blow up cross listings if it's not resolved in an acceptable way. So this is really the problem that Roberta was addressing in the second of her articles in our quartet. And it's sort of interesting, if you read her articles, you see how it was worked out in the EU-US context through long-standing bilateral interchanges between the EU and the US, and kind of an acceptance of some compromise of sovereignty that has kind of muddled through. That's been a little bit harder to do with the Chinese, who have a heightened sense of sovereignty. And also, you know, the tradition of working things out between the United States and China in the financial markets is not as well developed as it has been with the US and the EU. And of course, the current political climate does not make that any easier. But you can see the implications of Roberta's work in that area as well. The other thing that I would say, particularly for the fourth piece, is the substituted compliance that she wrote about in 2008 has really become even more important. And the issues that she kind of examined then, you know, really presciently, have really come to the forefront in two particular ways that I think her work resonates with. One is in the extraterritorial applications of the Dodd-Frank Act, which, like Sarbanes-Oxley, had a lot of extraterritorial application with respect to derivatives particularly, but also with respect to the Volcker rules, insolvency procedures. There's lots of areas where Dodd-Frank is extraterritorial because it's concerned with systemic risk and how well home country oversight in prudential areas and market structure areas is working. So we have sort of done a Sarbanes-Oxley extraterritorial application, but the only practical way to make it work is to accept regulatory structures in other jurisdictions that are substantially equivalent to those in the United States. The SEC, the CFTC, to some degree the banking regulators, have been spending a lot of time working in this space that Roberta was discussing about how close is close enough. And, you know, arguably the whole G20 structure of the post-financial crisis is to get, you know, equivalent standards to apply around the world. And, you know, Roberta was writing about them, you know, not before absolutely everybody, but before most people, and had some interesting things to say about this. And of course, Brexit, now that it's happened, is all about substantial equivalence analysis. And I think it will be perpetual substantial equivalence analysis as the EU decides how long the UK stays substantially equivalent to the European structures for a variety of directors that are of critical importance. So this issue that she was exploring, it's not harmonization, it's a descendant of harmonization. Roberta identified and wrote about insightfully. The final thing that I want to say about the piece is that you can see a trend line in Roberta's work away from full harmonization, away from everybody copy the SEC into something that's more accommodative. I don't know if Roberta would write this piece, but I might. There has sort of been an evolution to the point where the U.S. is no longer, I'll put it this way. In the old days, I think it's true to say that the SEC really did set the table for financial regulation, securities market regulation around the world. And at a minimum, it sat at the head of the table in something like IOSCO and in influencing the harmonization of disclosure standards and MOUs and other things that she chronicles. I think if you take a hard and realistic look at the last 5 years, you'll see that something very different is going on, that there's a lot of standards that are being set outside of the United States, and actually a lot of them in Europe, where it's not totally clear to me that the United States is at the table. If it is at the table, it doesn't have much of a speaking role. But you can think about this in the GDPR with respect to privacy. You can see this in competition policy with respect to high tech. A little closer to home with respect to the SEC, MiFID II and unbundling. This is an EU regime to deal with soft dollars. The SEC, for many years tried to deal with soft dollars. It basically exited the field about 15 years ago. And, the evolution that has occurred has been in the EU, and it's had a big impact on the United States. People are emulating what the EU has been done. We've already had some discussion of ESG. The EU has been ahead of the United States in ESG requirements. EU institutional investors have been insisting, often with regulatory requirements, for ESG disclosures and compliance. And U.S. asset managers and others have been, dancing to the European piper on this method. And they've, the United States is free to do what it wants, but it's doing it in the shadow of EU leadership on several of these issues. And, this is not something that Roberta talked about, but if you read her work closely, you can see this trend of SEC leadership sort of subsiding and maybe somewhat dramatically in recent years. And, I certainly think as I look at these developments, I, think about what Roberta has written. And I think that, the kind of scholarship that needs to be done today in this field is really very much the kind of scholarship that she did in those 60 plus articles. I've only been assessing 4 of them, but they're a rich 4. And they, have an important awareness of legal detail and political economy, as well as theoretical models. There is regulatory competition out there, but there's also lots of other things. And I've always greatly admired her work for being able to hold a lot of balls up in the air. And it's great for me to see that as she was commenting on the last panel, bringing up a couple of things that maybe some of the speakers missed. I'm sure I've missed something that she's going to bring up now to remind me that I've overlooked something important in retelling this story. But her work has been really rich and rewarding. And it's the mark of great scholarship that it's useful at the time and it's predictive of the future in an important and sort of unexpected way. So it's been I've been a happy reader, and I'm delighted to participate in today's celebration.
Okay, great. Thank you so much. So our first commentator is going to be Edward Green.
Thank you. I'm delighted to be here. I'm profoundly indebted to Roberta because she changed my career. We each went separate ways when we graduated from law school. She to government service, I taught for 2 years. But then in 1969, we both joined Wilkie Farr and Gallagher, and I was a capital markets lawyer. She then left for Rogers and Wells and then became, I think, the youngest SEC and first woman commissioner. And at that time, Carter had appointed Harold Williams to be chair of the SEC. And the concern was that our markets weren't being perhaps as efficient and effective as they could be. There had been a special study funded by the government overseen by Milton Cohen and supported by the SEC, that really took a thoughtful look at how our markets could be changed. And Harold wanted for the Division of Corporation Finance to do that, but he wanted to see if he could find someone with some practical experience as a capital markets lawyer. So Roberta approached me as a young partner and asked whether I would be interested in going to the SEC. And I'd always been interested in public service. And so I said yes, and off I went to the races. And I was then head of corporation finance from 1979 to 1980. And that's when we really began to do some profound changes in making our markets more efficient. We introduced, for example, integrated disclosure so that you could link your 10K to a prospectus. But probably most importantly, we implemented shelf registration, which addressed one of the key issues of our regulatory structure, and that is the uncertain timing of access to markets. And shelf registration for seasoned issuers provided instant access to the market and became a model that was followed by other markets, sort of reinforcing what Howell has said is that the SEC assumed that its structure would be followed by other markets around the world, so the compliance with the US rules wouldn't be particularly behind it. Now, Roberta was very helpful on the commission in getting many of these initiatives through with the comment period. And she was also at the same time interested not just in the US market, but in international markets. And in 1979, she and I were invited to go to Tokyo. And this is a picture of Roberta, me, and others. We were in Tokyo to visit the Tokyo Stock Exchange and the Osaka Stock Exchange to really talk about what are some of the impediments perceived by foreign private issuers from coming to the US and how we might coordinate. Roberta left the commission. I stayed on, and John Shad was appointed by President Reagan to become chair. And my interest in international issues for our markets really continued because John Fetters and I then went to Switzerland to negotiate the first MOU with the foreign government. We were trying to get information with respect to insider trading, but the Swiss government had secrecy restrictions with respect to our access. And we needed to negotiate an agreement pursuant to which, if we requested, supported by the government, that under certain circumstances, the Swiss government would permit that information to be made available. I left the SEC after 4 years, and I was interested in international issues, so I joined Cleary Gottlieb in Washington, and then in 1987, I opened its Tokyo office. I became the first licensed lawyer under the new regime, and then in 1990, I went to London for 14 years, and my experience was, under the influence of Roberta, was focused mostly on cross-border financings and the challenges that were posed by the SEC approach to cross-border offering. It was based, as Howell suggested, on the national treatment model. That is, if you wanted to come to the US, that was fine, but you had to play by the US rules. And the most important aspect of that, and probably the most costly, was that if you reported under financial accounting principles that were not US generally accepted accounting principles, you had to reconcile the results under your accounting principles to what they would have been in the US. In other words, the US would not accept presentation under generally accepted international accounting standards, which many markets used, but insisted that if you come to the US, you have to be able to be compared to US companies, and the only way that could happen would be through reconciliation. There was also no deference to the disclosure requirements with respect to other countries, and there was the assumption that the US market was so deep and rich that our markets would be attractive. And in the 90s, when I was in London, there was some aspect to that because that was the huge wave of privatization movements. And many of the European companies, especially the telecom companies that privatized, had such large offerings that they had to come to the US. And so the US sort of established itself as a market in which you could comply. It may be expensive, but it would be worthwhile. Well, that began to change as the consequence of being a public company in the US is basically sometimes unforeseen. Dodd-Frank, Sarbanes-Oxley, mine safety, other aspects that are imposed on a public company. That with the idea that the private market in the US now is dramatically higher than the public market. And that is the market to which foreign private issuers go to under Rule 144A. Because when we were at the SEC, in addition to the implementation of the regime I described, we adopted Rule 144A. And that is the way most foreign private issuers now access the US market. It permits underwritten private offerings with flow back into the markets where they may be listed. And that then raises the question is in some ways the US public market becoming a bit stagnant at a time when there's a call for diversity with respect to exposure of investments, and in the US, to the extent that foreign private issuers are in the private market and not necessarily going public or listing in the US, how do private retail investors have access? And that, I think, has really led to now more and more focus that the national treatment model basically has to be adjusted, and we have to face some of the issues that Howell mentioned, and that is mutual recognition or substitutive compliance. Now, there is a model we have with respect to mutual recognition. That's the Canadian agreement with a multi-jurisdictional disclosure system, where the Canadians can use their documents, vice versa, back and forth, and there's a reliance and close cooperation among the regulators. Sadly, that has not been extended to Europe or in Asia. And the question will be interesting to see is to whether, with respect to Brexit, given the linkage between London and New York, and London and the continent, whether this will lead to more discussion between the US, the UK, and Europe with respect to trying to come up with an integrated model. Because on the one hand, I do think that Hal is right. We're moving more to consider substituted compliance, especially with respect to regulation of intermediaries, broker-dealers, and investment advisors. But at the same time, there is a movement to try to achieve some form of international standards developed by the Financial Stability Board, or IOSCO. And this has come up particularly in the context of ESG issues, because what is important about those issues, environmental, social, and governance, bank regulators are increasingly concerned that the banks have information to assess the risk to their portfolio caused by regulatory response to what's going on with our climate and so forth. And so they're pressing to get agreed disclosure frameworks with respect to emissions, for example, into the environment or other types of activities that do threaten the climate, such that there's likely to be a regulatory response so the banks can assess how those assets can be carried on their balance sheet. And again, Europe is a bit ahead of the US with respect to this. We tend to, at the SEC, sometimes have fairly general disclosure requirements, relying upon private sector to implement it, but they can be so vague in general that they don't really tell much unless the comment period, the comments bring it out. That really hasn't happened in the ESG area, so there's a movement more and more to have that more detailed. In other areas where I think that there is going to be more of a call for coordination, and that is the regulation of stable coins and cryptocurrencies. I participated in a session run by the Peterson Institute about central bank digital currencies. There was someone from the Boston Fed, China, Japan central banks, and the European Central Bank. All of them were exploring digital currency. That can have profound effects with respect to our financial structure, cross-border movement of funds, trading in securities. And I think that will have to be addressed. And there, I think what we realize is the SEC really needs to be part of a wider group to participate in developing framework. One of the challenges that I think we face, and that Roberta has also recognized, is that unfortunately, we have the most fragmented regulatory structure of any developed country in the world, bar none. There's a consensus in the private sector that we should merge the CFTC and the SEC. The chances of that happening are zero because of the House. We have multiple bank regulators all addressing the same thing. There's a call for some type of international or national organization to oversee some of these developments in the market. We at Columbia are trying to get another special study funded by the government, which is not likely, to try to address some of the important developments that are happening in capital markets, especially with respect to technology and intermediation. And we're interviewed over 110 people to get ideas, and we'll publish a white paper on it. But still, I think that the real issue is that we need to have much more effective cooperation and coordination among regulators and debates at the level at the Financial Stability Board and IOSCO to try to take a common approach. And as you say, the real issue is that China is now the elephant in the room. And one of the interesting challenges is, as Howell mentioned, is this conflict that now China has in not permitting its books and records of cross-listed companies to be examined in China as required by the PCAOB. And this is the idea that the US will have its rules reach extraterritorially and not be prepared to rely upon foreign governments' oversight of auditing practices, that while it's prepared to defer to international financial reporting standards in terms of reporting, it is not prepared to make any difference with respect to auditing, to be sure that that system works. And so we will have this tension. And the interesting question will be whether this will lead countries like China and elsewhere to explore other markets in which they will find that they can list and trade their securities, in which the US will become increasingly relevant. And it may also explore why China is developing a central bank currency, because it wants to create situations in which the US can't use dollar sanctions to punish countries, and could provide alternatives for trading in markets that can basically bypass the US. These, I think, are many of the challenges that we face and that Roberta has always been quite willing to focus on. And that is, we have to be aware of international developments. We have to see that markets are linked, and we have to get away from the idea that the US market is the market where everyone would choose to be. It's the best regulated market, and there's very little to be critical about. That simply is not the case. And I do think that one of our challenges is going to be to see how what the impact is going to be on London with respect to Brexit. New York is clearly going to be a beneficiary of this. And the question is now whether the US will look to Asia to try to develop some relationships with Hong Kong. That's going to be a challenge because of Hong Kong's threat with respect to regulation in China, whether it would look to the continent to try to work out an arrangement with Europe with respect to substituted compliance or findings of equivalency, or whether it will simply continue to insist. Now, I think the concern is that will be faced by the SEC is that our public markets are not what they used to be in terms of number of IPOs each year and the number of listed companies. There are alternatives. And when there are alternatives, the question is, how do we permit our investors to participate in those alternatives? And to the extent that it's our private markets that is where you go, that limits the number of investors who can participate. So with that, Howell, I will turn it back over to you.
Well, thank you, Ed. I think, is Paul the next, Robin, in our queue? Thanks.
Thank you very much. This is really wonderful to be participating in today's program. I don't have personal stories about Professor Karmel, and indeed, by the fact that I call her Professor Karmel instead of Roberta may give me away on that front. Still, I do stand in awe of her professional work and her accomplishments and her impact on the commission, the securities laws, and securities lawyers. So for me, it really is an honor to participate in this celebration of her work. And maybe I joined a little bit late in the last panel, maybe this has already been mentioned, but when we talk about the fact that she broke ground at the SEC as the first woman commissioner, currently the SEC has a primarily woman commission, 3 out of 5. So we're moving in the right direction. And then when Linda Thompson talked about being the first woman who was a director of the Division of Enforcement, currently, when you look at the Home Office of Enforcement, all of the associate directors in enforcement are women. So 4 of them, and the acting director as well as the prior director are all women. So again, moving in the right direction. And so it's one of the many areas in which Professor Karmel has led, and the rest of us are getting smart enough to follow. today really wanted to focus on one of Roberta's articles that Hal mentioned, which is from 2008 and is titled "The EU Challenge to the SEC." And I came across this article after I left the SEC in 2018. I was doing some consulting work for the Sustainability Accounting Standards Board, SASB, about how you go about expanding its adoption internationally. I mean, it really had a lot of great things going for it in terms of having followed a model like FASB of standards being developed by professionals, by being open for public comment, having good governance, all of those things, and how to make it so it wouldn't just be seen as a US product, but would have the opportunity for broader adoption. And the obvious precedent for that effort would be the international adoption of IFRS, which I had the good fortune to have been involved in personally in a prior stint at the SEC, where I also at that time worked in the Office of International Affairs and also chaired the relevant IOSCO committee that was dealing with international accounting standards as well as with international disclosure standards. And what I did when doing this work with SASB, with talking to them, is I reached out to other people who were involved in the process to get their perspectives, and then looked for things that would be worth reading to sort of get a broader perspective. And as I did that, one of the things that various people mentioned to me and was Roberta's article from 2008, and which I then read. And what I found was it was far more informative and helpful reading her article than talking to people who had been involved, because people who had been involved in the process had their narrow perspective. And what she brought to the discussion was she pulled back some and looked at the things that were motivating, authorities or, in different jurisdictions, with a particular focus on the US and Europe, but in other places as well, with respect to international markets, international disclosure standards, and international accounting. And it was, this effort to cast a broader net to look at things from, multiple perspectives that made it so that in 2018, and indeed today, as we think about ESG and a way forward, that her scholarship really is quite relevant. And for that, I really want to thank her. And I am going to focus today on ESG. It's been mentioned by various people already. And, it is an area where, the US is behind. It wasn't just, not at the head of the table, for a period of time. It wasn't even at the table, as others were looking to develop an international or even a domestic approach to ESG. And I think we're moving in the right direction now, but have a lot of catching up to do. But Roberta's article, the 2008 article, looked at the SEC's adoption of IOSCO's disclosure standards for foreign private issuers through 20F, the annual reporting form for foreign private issuers, as well as the development of international accounting standards, now known as IFRS. And IFRS is really what I want to focus on when talking about ESG, because it is what any set of ESG standards would want to be, which is internationally recognized, useful for cross-border listings, giving issuers the ability to use one set of standards in multiple jurisdictions. And Professor Karmel really talked, insightfully about the pressures on the SEC, the authorities in the EU and other players to really get behind the development of these, internationally agreed upon accounting standards. And, one of the questions will be, of course, whether those kind of pressures or those kinds of motivations, whether they really apply to ESG, and in fact, how all of this will work out. So I'm going to talk briefly about some of the lessons from the historical process, and which are recounted in Professor Karmel's article, and then talk about how they might play out at the SEC as well as on the international, in the international area, through organizations like IOSCO and the like. In terms of thinking about the development of what is now IFRS and the ESG standards, there's some of the factors are definitely the same, right? So when talking about pressures or motivations, you have companies, you have markets, you have investors. They all want internationally consistent and comparable ESG standards. Of those players, I don't think there are any who say, gosh, it would be nice to have a national standard that is different yet credible. Because many of the companies, for example, that will be thinking about implementing these, and for whom it's significant, are companies that operate on an international basis and will want to have something that is an international standard. And so for the companies, markets, investors, the consistent or comparable, regulators also want comparability. They also want high quality, right? And that is, I think, a message, obviously, that the SEC communicates about international accounting standards, and was a key to the adoption of IFRS as an option for foreign private issuers, but would also apply broadly, I think, to regulators on the ESG front. One of the differences, thinking about ESG and specifically potential adoption in the US, is there is no powerful incumbent, right? There is no US GAAP, there is no FASB. So there isn't a situation where you have, sort of an entrenched incumbent and that wants a particular approach, nor do you have a situation where, companies and others might be reluctant to embrace change because of its impact on their powers as incumbents. What you have, I think, again, as you did, you have with ESG explicitly as you did with IFRS, is that you have IOSCO, the International Organization of Securities Commission, wants to play a leadership role in the process. But its leadership role, and it has, recently put out a press release about about meetings that it's had, consultations that it has underway, and indeed on the path forward it wants, which is something that would be, under essentially the broader umbrella of the IFRS Foundation. It wants all those things, but it doesn't actually want to be the one developing the standards. That's not a good role for an international body like IOSCO to try to be a standard setter. You want experts to be the standard setter. You want independent group to be the standard setter. Just like in the US, you don't have the SEC setting accounting standards. You have FASB internationally. You have the IASB setting the IFRS standards. But IOSCO is clearly positioning itself to have a governance role with respect to ESG standards, as it does now with IFRS. And I think, and there's a lot of logic to that. With respect to what that oversight might be, that involvement at the high level by IOSCO, by the International Grouping of Securities Regulators, you can again look at the IFRS model, which the SEC had a big role in developing, and indeed governance was probably much more of an issue for the SEC than many other regulators when the IFRS Foundation was being set up. Is in that governance, the EU, I think in particular, is going to look at its experience with the governance of the IFRS Foundation, which is done through a body called the Monitoring Board and think about the shortcomings of that approach from its perspective, and whether it's going to be willing to follow the same path with respect to ESG. And so one of these questions that I think are challenges about this notion that I think we would all support, which is a international high quality set of ESG standards, is on governance, is who governs. And when the group, this monitoring board, was set up in the IFRS Foundation, some of the the original members were the European Commission, the SEC, the Japanese FSA, and then there may have been a few others, but those are sort of the important players. And the SEC and the EU were or EC were on equal footing. They both had the same vote. They both had the same say. But the difference was, in Europe, IFRS standards were being adopted as the national gap, or the gap across the union. In the US, they weren't. And that's something where I think Europe, when it looks at governance over ESG, is going to ask the same question, which is, if the SEC wants to have a leadership role on governance, is it also going to take a leadership role with respect to implementation? A second issue that is critically important, and another, I think, rubbing point for the EU, is who pays? Who pays for this group that will set these standards? For the IASB, the actual standard setter for IFRS, the payments that come in are, for most part, from national authorities, as well as from the European Union as a body. The payments from the US there are no government bodies. The SEC doesn't pay, the Fed doesn't pay, Congress, no one pays from the US. Again, a sore point for Europe and a sore point for others. There've been extraordinary efforts by the SEC to try to find a way to pay, to see if there was a way to get money from Congress, if there's a way to find other funding. 1 year FASB used some of its excess funds to make a contribution to the IFRS Foundation, for which it was roundly criticized. So that will be an issue too with respect to ESG. And then the biggest issue is who adopts, right? And so going back to IOSCO disclosure standards, the SEC, wasn't just at the head of the table. The SEC basically provided the table and decided on the seating and made the decisions, many of the decisions on the IOSCO disclosure standards. It chaired, from the beginning, the relevant IOSCO committee. It had the most expertise. It had the most manpower. It shaped those standards. For IFRS, for what became IFRS standards, the SEC really played a very active role in sort of setting what standard the IASB standards need to reach before they be considered for adoption for IOSCO or endorsement from IOSCO. They were very engaged in an active dialogue with the IASB directly. They were very engaged through IOSCO. They really helped shape that. On ESG, it's very different, right? So absent from the table, Europe having, spent extraordinary, really focused on ESG, setting it as a priority, making it a priority at the union-wide level, at the national level, where there, is extensive work that's been done on disclosures, where there is, there are standards that are moving forward. Europe wants to lead. Europe is leading. And the real question is, can the SEC catch up? And I'm interested, assuming we have time for, that others may talk about that. And I know that Eric, in his role at the ICI, has expressed a view on, which of these standards should win out. So in her article, Roberta really notes a challenge of other markets to the SEC's dominance and the possible rise of those markets, and Ed mentioned that as well. And on this particular issue where the SEC is not dominant, the question will be, based on its institutional strength, based on the motivation of its current chair, the fact that he is clearly prioritizing ESG, whether this is something where the SEC will make the effort to really join and shape and help lead the international effort, or whether instead it will go its own way, and whether by going its own way, over time, the US ends up with its own incumbent, and as a result, there's less and less chance for an internationally agreed approach. So with that, I will turn it back to the chair of the panel, and thank you.
Sorry, I'm really bad at unmuting. So thank you very much for that. And our last commentator is Eric.
Great. Well, thank you very much. I am very happy to be here. I have not spoken to Roberta for a number of years, but when I was an academic, I used to speak to her quite often. And first I want to pay tribute to her as a person, because she always, as her Brooklyn colleagues have already attested, she really was an incredibly generous mentor, advisor to many young scholars who were starting off in their careers. And, I had spent 4.5 years across the river at Cardozo, and I would occasionally be allowed to cross, take the subway over and to visit Brooklyn Law School and to attend the conferences and to speak there. And I always really appreciated that. I think the other thing that I would say that I really appreciated of Roberta, and how kind of addressed this a bit already, which is the type of scholarship she did. The type of papers that she wrote were not the papers that would get you tenure, meaning they were not the papers that that had beautiful theoretical frameworks or that showed wonderful econometric skills. They were papers that cared very much on solving problems. And for me personally, I liked that scholarship. I liked it very much. And Roberta, given her stature, given her role leading the Block Center, was someone who I actually looked up to a great deal, because she showed that you could do that type of scholarship in a way that was rigorous, but was also really important. And I think I want to start off my remarks by first commenting on this personal aspect, which is that what made Roberta's scholarship kind of so important to someone like me. And I think there's really kind of 3 different kind of ingredients in a lot of the papers that she wrote, including the 4 that support this panel. First is a real desire to understand how things work. These were papers that were not afraid to actually spend some time explaining what exactly was happening in the market today. I fear that sometimes that type of work is underappreciated, because as someone who is no longer an academic, it is incredibly complex out here. And it is very hard to think that one can actually comment very much effectively on anything unless you can show that you actually have a good handle on what exactly is market practice. What exactly are the trends that are going on? A second ingredient is the strong comparative approach that Roberta brought, especially to her international papers. She was a pathfinder in terms of the amount of time she would spend talking about what was happening in Europe, at a time which it wasn't really in vogue to look to Europe, especially in the context of financial regulation, as really a place to study. And I would say that the other person who really broke this ground was Hal Jackson. But But beyond Hal and Roberta, there wasn't much work going on in the space of securities regulation, banking regulation, and US Europe. But this proved to actually be quite prescient because Europe was a laboratory in many ways. It's a different market, it has different characteristics, and it developed regulatory solutions, regulatory approaches that, as we talk about today and the extraterritorial impact of European regulation, one wonders, maybe more Americans should have spent time learning about Europe 20 years ago, and maybe we would have been better prepared to handle the world we live in today, where we are being so heavily influenced by these European requirements. And the third ingredient is the kind of willingness to make policy recommendations, to basically not only say, this is what's happening or this is the problem, but actually to say, but this is also what we should do about it. And this willingness to make policy recommendations, and again, speaking in the context of someone who was a young academic at the time, it seemed pretty gutsy for an academic to be able to do this, especially a young one. Roberta could get away with it because Roberta, being a former SEC commissioner, had the stature, she had the position. No one was going to ever question Roberta and her ability to say this is what we should do. But that type of work was also really important because it was also a form. It was a form of debate that I think is lacking in a lot of our discussions about financial regulation, especially in the academic world. And I say that because I left academia. I did join the SEC. My intent was not to stay at the SEC, but I ended up staying a lot longer than I would think. And frankly, the scholarship that Roberta did was much more useful than most other scholarship out there. And I speak to this firsthand. In thinking about many of the challenges that the SEC had gone through between 2010 to 2015, the immediate post-Dodd-Frank world, the rise of the FSB, the empowerment of IOSCO, the creation of these new cross-border conflicts, the need to develop new regulatory approaches to deal with novel questions, whether it be conflict mineral disclosure or regulation of benchmarks, or how to remove credit ratings out of financial regulation, or the always popular OTC derivative space. Roberta's scholarship was useful. It was helpful. And I want to pay tribute to her for that because I think there's many different ways of evaluating quality of scholarship, but on one metric, she was on that particular metric, she was incredibly successful, and her thinking proved to be quite influential in many different ways. So the other comment I would make is Roberta as an educator, because I think that law professors in particular, you write not only for each other, but you also write for your students. And I think that it's no surprise that many of our leading journals are student edited, because there's always a notion of, well, the students, it's a form of training for the students as well. And here, speaking as a former regulator, not as a former academic, I've always been amazed by how hard it is to find new regulators. I have hired dozens of people for both the SEC and the CFTC, and I can tell you how hard it is to find really good candidates. It's not hard to find smart candidates. It's not hard to find credentialed candidates, but it's really hard to find people who are equipped to be regulators. And I think, in this regard, Roberta's scholarship, if I were to design a graduate program to train financial regulators, Roberta's scholarship would be the type of papers that I would assign, because it would force students to think about problems in very practical ways, but also almost like in a case study method, look at certain regulatory problems and try to draw connections. So when we talk about things like deference, substantive compliance or equivalence, when we talk about things like extraterritoriality or whether or not there should be a single securities regulator in Europe, these are big questions, but these questions constantly come up in different regulatory contexts. And to have people be trained in how to think in these concepts and to think of these methods is actually something that we need today in our regulatory agencies. So, in terms of actual international issues, I don't want to take up too much time, and so much has already been said already, but Paul Leader did call me out on the topic of ESG. So I will speak just very quickly about ESG because obviously in my current role here at the ICI, I've been doing quite a bit of speaking on ESG, but let me try to frame it in an academic way. Paul has laid out the problem quite well. We have a situation where we have a cross-border problem. So climate is an international problem. We have competing jurisdictional approaches. We have different legal systems all coming into play. But also we have different markets. So when we talk about sustainable finance and corporate disclosure versus sustainable finance and bank capital rules, they're important to both the US and Europe, but some are a little bit more important to Europe than it is to the United States, given the size of our capital markets here in the US versus the importance of the banking sector in Europe. And when we look at places like China and Japan, we can see also other types of characteristics that we have to watch out for. The fact that China has a nascent asset management industry, and it still has a very heavy retail participation in the markets that seems a lot closer to the type of participation we see in places like GameStop, rather than the classic long-term investor that we always hope Americans act like. Whereas Japan, you have a very mature market where you have a population with people with high savings, but also an aging population, and a market which does not have very much international exposure. Japan tends to be pretty closed in many different contexts. Then when we talk about ESG and sustainable finance, clearly we're going to get different answers in each one of these places. And here, just to kind of, if what would be my policy recommendation is, it's got to be a combination of an international framework, whether it be the IFRS Foundation using a SASB TCFD framework, combined with a US disclosure approach that is designed for the United States, meaning a European disclosure requirement based upon NFRD or what they're doing with fund disclosure, in my opinion, would not work if it was to be applied to the United States. And so that's the complicated problem that we have to solve, which is how do you have international harmonization while also having distinct national markets? And here, substitute compliance or some form of deference would seem to be the playbook. But I leave kind of, I guess, a last comment here, and that is, that's the playbook we would have said 5 years ago. Query in 2021 if that's the playbook that's going to work this now. As to what's the alternative, that's very hard to say, and I think would be the topic of another conference altogether. So maybe Roberta could write the next article answering that question.
Thanks, Eric.
Thank you.
Okay, great. Thank you so much. So at this point, I'm going to give all of our panelists a chance to just comment on the remarks that you all have given. I know that we, in talking before, had a lot of dialogue. So I would just invite a little bit of that dialogue. And in the meantime, if any of our other panelists would like to ask a question, feel free to raise your virtual hand. And those of you who are in the audience, feel free to post a question in the Q&A, and I will start kind of funneling that into the discussion as well. And maybe to kick it off, since it's in a virtual format, it's hard to sort of read who's going first. I really sort of like the idea of picking up on the general themes of harmonization. For one thing, Eric, that's where you ended your remarks. It's obviously sort of a real through line with what many of us were talking about today, because that question of sort of the tension between domestic regulation and also the utility and ease and efficiency of harmonization, I think is sort of maybe where we could get some of the remarks going, if anyone wants to sort of further pick up on that thread.
Well, let me just say, I think the ESG question is a super fascinating one. And, Eric pointed out the differences in market structure, and that's certainly the case. And just having China in the mix, having to think about things, complicated because it's just a quite different market than Europe or Japan or the United States. The other thing I would say, though, is I think the vision of securities regulation also kind of differs. It's not just based on markets. It's based on what the goal is. And as I understand the European vision, it's not simply about investor protection. It's not about financial materiality. And you can sort of, in the Gensler hearings, you can see some of the Republican senators saying, wanting Gensler to say, don't you agree that if it doesn't have a financial impact on the investor, then it doesn't need to be disclosed? And, Gensler kind of skirted that question. Clearly, the question wanted a yes answer. But I think if you said that in Europe, the answer would clearly be no, that there are social things going on. There's kind of social organizing and rallying, and sort of a substantive commitment that's beyond clearly that's one of the things that goes on in US exceptionalism about securities regulation, about conflict mining and other things. But we're deeply divided about how far beyond market efficiency we go with disclosure. But I think in the ESG space, there are countries, particularly Europe, that are just in a different space. So I don't know how we get to harmonization when there's kind of different projects going on. But Eric, I guess maybe Paul, that I should put the question to you, since if you're trying to get the EU on board with something that we're going to do, how are you going to negotiate that gap, or am I misperceiving the gap?
Well, the part of it is hopefully what you're doing is you're turning it over to a third party that is not the EU, is not the SEC, that is trying to come up with a good solution, and that you're pulling back the SEC and the EU to the oversight level, like you do with accounting standards. But if we get into a situation where we're actually trying to agree on specific standards, then you're talking about just an extraordinary challenge for the reasons that you state. Europe is, my guess, is in a different place than even maybe the most progressives at the SEC are. Maybe not, but I think that's going to be a really difficult challenge, and that's the beauty of, essentially finding a group that you say, needs to follow certain approach to setting standards, as compared to trying to agree internationally at the regulator level on what those standards should be.
Yeah, but just as you said, that the EU is now looking under the hood of governance and kind of what the terms are. This Republican senator is also looking under the hood and having similar questions about who this third party is and what is the direction. But I think we all aspire to do things, but it's, in some ways it was easier. We're all saying that more people should do work like Roberta and revealing what's going on. One of the problems about revealing what's going on is then we all understand, and there's a cost of transparency.
Howell, I think also will be whether the Financial Stability Board will be effective, because that's a board that people had looked to really try to develop standards and to push countries that are part of the G20 to implement it. And the question then, I think, is whether the SEC is really prepared to support that and accept recommendations that may be inconsistent with, as you say, our disclosure policy. Because I do think that disclosure will be used more and more to shame to change conduct, which it was in sort of an ad hoc way by many of the things that Congress added on to other bills. But really the question I have is how much we want to play internationally, where we're not going to necessarily be the leader, whether we may be outvoted or have to defer to where Europe and Asia may come together. And that's not something we've been particularly good at in the past.
I would comment that I think what's really interesting in the case of ESG is when you talk about ESG in the United States, people cite, well, there was a Supreme Court decision that defined what materiality means. Or, you know, under this regulation, this is what the disclosure needs to be. When you go to Europe and you talk about ESG, they talk about we have a duty to society. This is a von der Leyen priority, you know, et cetera. One of the challenges in dealing with Europe in terms of US-European negotiations, and Paul and I saw this because on things like the financial market regulatory dialogue, it was often the SEC talking to the European Commission. The European Commission is a political body. It's not a financial regulator. And so right there you have sort of, you know, Europe is from Mars, you know, the United States is from Venus type of problem, which is you're just starting from different points. You know, the SEC talks about we have a statute. We're not here to make public policy choices. That's Congress's role. That just does not fly at all. And you know, ESG. What makes ESG kind of now more pressing is it's not a low politics issue. It is high politics. When John Kerry meets with Bruno Le Maire and starts talking about ESG disclosure and taxonomy, then you know this is not going to be decided by some staff lawyer in Corp Fin. It's going to be decided at a much different level. And the question is the SEC prepared to engage at that level?
Eric, can I shift the debate? And it's clearly related, but this point, which I actually think I initially got from you a couple of years ago in a side remark about the SEC no longer sitting at the head of the table. I don't know if that was your metaphor or I picked it up somewhere else. But since you were at the commission and the CFTC in relevant times, do you have any explanation about the pulling back of engagement or the perceived pulling back of engagement that kind of distinguishes the recent past from, you know, the late 1990s turn of the millennium?
Yeah, so yes, I have said this, and so Paul Paul's too far away to kick me under the table like he used to, but I would say it's a function of the SEC as an institution, and it's a function of the SEC kind of being slow to recognize the challenges. As an institution, you know, of course, like any administrative agency, it's got the APA, it's got a 5-person commission. It's a very deliberative body. And so when an SEC representative, even if it's the SEC chair, he or she can't go to an international meeting and say, this is what the SEC thinks, because there wasn't a commission vote. There wasn't a rulemaking that went through notice and comment and cost benefit analysis. All they can say is, well, this sounds reasonable, but until the commission actually takes action, we can't tell you what our position is. Now, this works beautifully if you're using the current SEC framework. It works terribly when you're trying to develop standards in areas where the SEC has not yet developed an answer. Dodd-Frank, clear case. It's been 10 years. The SEC is still implementing Dodd-Frank, but a lot of the Dodd-Frank regulatory questions were addressed in the FSB in the first 5 years, right? And so right there, the SEC is instantly on the defense, and it's unable to actually try to strike deals. Other jurisdictions and other authorities do not have that same problem. And in fact, frankly, the CFTC pretty much just took a different interpretation as to what it meant to have a commission position. in that the CFTC chair always was more willing to kind of stake out a role, stake out kind of a position. But I think that's also a function of the difference between the CFTC and the SEC. The second is sort of the awareness. So Jay Clayton was famous for saying that, when you look at Jay Clayton's first speech, which he gave at the New York Club, the Economic Club in New York, he lists all his priorities. None of them are international. 2 months later, he's quoted in the press saying, I am spending more time worried about MiFID, and that's taken up about 90% of my bandwidth right now. Meaning that the international issues were not something that he thought he had to worry about, and it ended up becoming a significant part of his world. I think any SEC chair today needs to understand you have to take international affairs seriously. I think the growth of the Office of International Affairs is a sign of that. I mean, OIA, when Paul Leader was there in his first round, it was probably 5 people? What was it? Yeah. Now when you left it, you were at over 50?
About that.
Yeah. A 10-time increase. And frankly, it probably should have been even larger, given the amount of the international work.
So as a not having ever been a commissioner, and only looking at things from a staff perspective, MiFID II, for example, was something that the staff, at least within OIA, very focused on years before Jay Clayton showed up, and bringing it to his attention and trying to get it on his agenda, and just as we would with any chair. And I think that where I do differ with Eric somewhere, he talks about the SEC, whether it's leadership or not. And, part of that leadership, I think, particularly when you're talking about an international organization where people are trying to go off in all sorts of different directions, is do any of those things that actually occur, that you permit to occur, harm your interests? And from the SEC's perspective, I think that those things don't occur. Whether the SEC chair chooses to chair a particular committee or a particular, task force or the like is a different thing. But I do think that the SEC continues to assert substantial, authority when dealing with those kinds of organizations on issues other than ESG, and that may change now. And on ESG, the SEC was hampered by Congress basically saying, don't spend time or money on ESG. Where if there were a IOSCO statement about ESG, one could expect pushback from Congress, pushback from certain members of the commission. That has changed for the moment, or at least as to majorities in Congress and majorities at the SEC. But that's, I think, an issue where the SEC, even the staff, wasn't able to lead and sort of influence the agenda.
3 words: money market funds.
So I have a question from a participant to pose to you in the last few minutes of our session. So in the last panel, Roberta highlighted the difficulties that the SEC is likely to experience due to heightened political partisanship. So to what extent is that heightened partisanship in other countries, for example, the rise of populist nationalist groups in Europe, likely to impact the SEC's extraterritorial efforts, and also any attempts at harmonization, which of course go beyond the SEC?
I can give a quick answer, which is Europe tends to be more isolated from those tendencies only because the European Commission is this professional bureaucratic body that really is driving a lot of things. So even if you have wide swings, you're not going to see kind of the same swing happening in Brussels. Where it does come in is usually in isolated areas. Sometimes you may have, like, I'm going to pick on the Greens. The Greens may have a very influential role in the economic monetary committee of the European Parliament, and so they may throw in some things into the legislation. But it tends not to be impacted too much.
I agree.
Yeah, no, it's really striking. I think the growth of dissenting opinions. It's interesting to recall Roberta's dissenting opinions which strike me as I hear about them as reasoned and collegial, whereas you read some of the dissenting opinions now from the commission, and it seems like floor debates in Congress, and it's just hyper partisan. And as far as I know, you just never see that at the commission level, that kind of partisanship and dissenting opinions that unfortunately characterizes a lot of our commission results now.
Sorry, to cut in, we only have a few moments left, but Roberta has raised her hand, and I want to make sure we give her a chance to comment on all of the really interesting commentary we've had so far this afternoon.
Am I muted still? I know my face isn't showing. I don't know why, but can you hear me?
Yes.
Yes. Okay, great. I just want to thank all of you for this very interesting panel. Sometimes I was thinking, did I really say all that way back when I was writing these articles? Was I that prescient? I particularly always liked my article recommending that the EU should have an SEC, because I wrote that one day when I was on a vacation on a cruise. We were stalled because of weather. I had nothing to do. I wrote that article and I submitted it for a conference that was held at INSEAD in France. And I had a wonderful time there. And then this turned out to be one of the most controversial articles I ever wrote. I was attacked by regulators from all over the world, and particularly in Europe, for writing this article. And I thought, oh, gee, I just wanted to go to this really nice conference in France. And I'm glad that it hit a chord, but I think it's still kind of relevant in a lot of quarters, and that more now than was true then, the SEC can't just impose its views on the whole world and securities markets everywhere. And I think that is one of the consensus views that all of you have been expressing. So just thank you so much for this interesting panel and the way in which you have complimented me. I don't really deserve it.
Well, that's not true. Luckily, we have a whole session in about half an hour where we can tell you how untrue that is. So I will, I think, hand this back over to one of our organizers to sort of let people know where we go from here. But I would like to thank so much our panelists from this past session for a really great discussion. I found it really interesting and illuminating, and I hope everyone else did as well. So thank you very much.
Thanks.
I'll jump in here. Thank you, everyone, for a really great day. The next session, you should be aware, is on a different Zoom link. It is in Zoom rather than in webinar. You should have received that link with the original email that you received, but when you log back in, we are going to be turning this link off. So come back to the one that says for the celebration rather than for the symposium or program. Thanks, and we'll see you all there.
And just to remind you, if for some reason you can't join us later tonight, tomorrow the symposium continues at 9:30.